Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3069, United States of America versus John Marone Nassif. Ms. Fusel for appellant, Mr. Cahill for appellee.
Good morning. You may proceed when you're ready.
Good morning, Your Honors, and may it please the court. My name is Melissa Fussell, and I represent Mr. Nassif. The First Amendment issue is before the court because in 1967, driven by a desire to stamp out civil rights protests, Congress hastily passed legislation banning parading, picketing, and demonstrating in the Capitol buildings over objections it lacked the authority to constitutionally do so. That law, now 5104 E2G, is both unconstitutionally vague and overbroad. First, E2G is unconstitutionally vague. Its uncertain meaning chills free exercise and it invites arbitrary enforcement. The government has exploited E2G's ambiguity by selectively advancing contradictory interpretations. This past May, opposing a motion for acquittal in United States versus Ballinger, the government argued that E2G should be construed literally to include even non-disruptive expression, like silent, reproachful presence, or just simply showing up at the focal point of a person's beliefs. But below, it adopted a contrary position, demonstrating means engaging in disruptive conduct. And now the government argues that E2G prohibits demonstrating of the type that would tend to disrupt the orderly business of Congress. It doesn't tell us what it means by the type of disruption, how general that is, what that might include, whether that refers to topic or time or number of people. And it doesn't tell us what it means by the orderly business of Congress, although it apparently means something that takes place when Congress is not in session. It doesn't tell us whether a minimal disruption is sufficient or what even it means by disruption, something more extreme like an obstruction or an impediment, or just simply a distraction.
Ms. Fussell, what if we read demonstrate in the context of a prohibition on picketing, parading, and demonstrating to denote showing up at the Capitol for the purpose of expressing support or disapproval for an identified action or point of view? So the reason for being there to bear witness to one's, objection or support, why isn't that the most natural reading? And in what way does that conflict with the government's position here?
Yes, Your Honor. So if I understand the way you've defined it correctly, I think that's exactly what it means, to show up at the Capitol buildings with the intention of expressing some kind of viewpoint. And I think that's blatantly unconstitutional. So the government, the interpretation that the government advanced most recently, and we'll have to see what interpretation they advanced today, but it was that it prohibits demonstrating of the type that would tend to disrupt the orderly business of Congress. The definition Your Honor supplied didn't have any kind of component like that would tend to disrupt.
Well, so I'm not sure that I read the government's position to define demonstrate as what would tend to, but more that that's their description of the interest behind this provision. So they do have, as you point out ably in your brief, there's already a prohibition on acting disruptively in the Capitol. But the Capitol has a lot of visitors throughout the year. And even more so, Washington, D.C. has thousands of demonstrations every year. Why is it not constitutionally permissible for the Congress to maintain the internal areas of its buildings as non-public fora and to prohibit an additional category of visitors, people who are not there for other purposes, but would only be there because they wanted that to be a stage for their picket, protest, or demonstration, and simply to say that the capacity would be really strained if we opened for that kind of activity. And so there's a tendency, we can't say, we're not turning our interest on every single one of these being disruptive, nor honestly could they, because they allow similar sized groups for other purposes. But it's reasonable for them to say this category of activity, which people are constitutionally entitled to engage in outside, just would overwhelm the ability of the Congress to do its work if we invited that in. Why isn't that constitutionally tenable?
Yes, Your Honor. So as a threshold matter, we would argue that portions of the Capitol buildings are public forum, but even in a non-public forum, the prohibition must be reasonable in light of the purpose served by the forum. It's not enough to be rationally related to a legitimate government interest, as this court made clear in Price versus Garland.
But what if it's not a public forum at all?
Yes, Your Honor. So if it's not a public forum at all, then it still must be reasonable in light of the purpose served by the forum. And it's not enough for it to just have a rational relationship to a legitimate government interest.
Well, if it's reasonable in light of the purpose of the forum, which is to conduct the business of Congress, and we know that were it opened to parading, picketing, or demonstration, there would be very high demand for that use. Why, as a matter of security, of potential for disruption, crowding, why isn't that enough of a governmental interest?
Yes, Your Honor. So, and again, it's important that it's reasonable in light of the purpose served by the forum, which is legislating. So the function of the forum, even if it's a non-public forum, demands access to the people that are elected our members of Congress. So demonstrating is really essential to the purpose of the forum. And so we're not saying that Congress doesn't have the ability to regulate crowd control, or that they can't, limit the number of people in an area at a certain time, or that they can't limit noise. Of course they can limit those things. However, as the Supreme Court said in Minnesota Voters Alliance versus Mansky, the government has to be able to articulate some sensible basis for what stays in versus what comes out.
But you can petition the government without parading, picketing, or demonstrating. Right?
Correct, Your Honor. There are other ways to petition the government. However, the fact that you can use your First Amendment rights in one place is not a basis the Supreme Court has said.
No, I'm saying you can petition the government inside the Capitol building by meeting and speaking with the legislators or their staff without parading, picketing, or demonstrating.
Respectfully, Your Honor, it's not at all clear that that's the case. So the government opportunistic.
You're telling me that this statute keeps a lobbyist or keeps a farmer from Iowa from going into the Capitol and speaking to staffers?
Well, Your Honor, if the government's argument in United States versus Ballinger is to believe, yes, they argue that demonstrating need not be organized or an outward conveyance of views, and that it includes even silent and reproachful presence, as well as merely showing up at a place that was the focal points of their beliefs, regardless of how quiet or peaceful they are. And
read it in the, sorry, I didn't mean to interrupt. You can finish your
no, go ahead, Your Honor.
So if we read it as demonstration being akin to picketing or parading, and to exclude, as Judge Wilkins suggests, people who are there to meet with people by appointment to present views and that kind of thing, then we're really saying people who are there only for the purpose of standing, bearing witness, even silently, yes, but that sort of create this additional population, additional reason to visit the Capitol. If that's what the statute is aimed at, then I'm not sure I see your rebuttal point to that.
Your Honor, our point is that banning that would be unconstitutional because it's not reasonable to single out First Amendment expression, peaceful, quiet, non-disruptive First Amendment expression in particular, for the sole basis that it's First Amendment expression. So to hear the government tell it, as long as Congress is not in session, a person can engage in all manner of disruptive conduct in the Capitol buildings as long as they don't engage in First Amendment expression while doing it. And it sounds like the definition that your honors are offering is that if you come for the specific purpose of expressing yourself and making your views heard, that's illegal. And that simply cannot be the case under the Constitution. That wouldn't be reasonable in any forum.
So you're focusing on the most extreme, maybe minimal is the better word, minimal version of demonstrations in your responses to these questions, right? But this statute would prohibit not just the quiet person maybe holding up a fist, but also all other forms of demonstration. And when we're doing a reasonableness analysis, not narrow tailoring, if you assume it's a non-public forum, why is that type of over-inclusiveness a constitutional problem? Isn't that exactly the difference between reasonableness and narrow tailoring?
Respectfully, no, Your Honor. So the government in its briefing approaches it as something like a rational basis review, which is different. So reasonable in light of the purpose served by the forum. The Supreme Court has says you have to be able to articulate why. Give a reason why you're not banning this, but you are banning that. And so it's not reasonable if your concern is preventing disruptions of the orderly business of Congress. It's not reasonable to say we're only going to punish the First Amendment expression that does that. We're going to permit all manner of other disruptions as long as Congress.
No,
There's
that's
a
my
separate statute that prohibits disruption.
Correct, Your Honor. But as the government points out in its brief, that only applies while Congress is in session. So the government has argued that there's a gap in the statutory scheme. While Congress is in session, subsection D prohibits disruptive conduct. But while Congress is not in session, then there is nothing to, in that specific statute, to prevent any kind of disruption. And that's where the government argues, for the demonstrating provision comes in. However, if Congress is aiming to prevent disruptive conduct and they're concerned with Congress being able to do other kinds of orderly business, it is not sensible at all to only punish the types of disruptive conduct that the Supreme Court says are worth protecting in spite of their risk for disruption, and maybe even because as the Supreme Court has made clear repeatedly, the free exercise of speech is most important sometimes when it creates a condition of unrest or when it questions people's beliefs. Even going into the Capitol buildings, if you go into that visitor center, there are signs explaining how you can participate in your democracy. And one of the things that it invites you to do is to come to Congress and talk to your congressperson and make your views heard. A statute that might prohibit that, and at least some of the government's interpretations, as along with the Capitol Police's interpretations and even the definition of demonstrating elsewhere in the DC Code, at least suggests that would be prohibited. And that type of chilling of free exercise.
I think where you're losing me is that if the choice is between demonstrating on the sidewalk outside of the Capitol or demonstrating inside the Capitol building, if you give that to 100 different groups that seek to come to Washington and demonstrate, 100 out of 100 would pick demonstrating inside the Capitol building. And I think that at least where I see your argument running into a problem under a reasonableness analysis is that, isn't it reasonable for Congress to just conclude we can't get our work done if there are going to be, dozens, if not hundreds of demonstrations occurring in the halls, in everywhere, every day on a daily basis.
So, Your Honor, I would say that's not a reasonable way of preventing that kind of disruption. So what would be a reasonable way, perhaps a permitting scheme, much like they have for the Capitol grounds elsewhere, We're not arguing that you just need to open the floodgates and let anyone who wants to have some sort of large protest in the rotunda go through. Of course, that's not the case. But what we're saying is that this statute doesn't offer any kind of guidance. The government can't decide what it means. The Capitol Police can't decide what it means, and district courts can't decide what it means. No one can figure it out. So as it stands, then anyone who
We
wants...
can tell them what it means today.
Well, Your Honor, if the court can ascertain the meaning, then that's absolutely correct. However, what the court is not permitted to do is rewrite the statute. If there's not a basis for concluding with that there's some kind of narrower meaning than what everyone else has advanced, then the court can rewrite the statute. But regardless, there are, of course, reasonable ways to limit that kind of activity in the Capitol building. But here it would appear, and the government has argued in other cases, opportunistically, that it would reach even a lone person walking into the Capitol and silently having a reproachful presence there. So that's absolutely not reasonable.
Can I just
Go ahead.
ask a procedural question? It appears that you concede in your brief, I think it's at page 15, that you did not make the argument below that the Capitol buildings indoors were a public forum. And you didn't make the argument in your opening brief that they are a public forum. Am I right about those two things?
Could you repeat the second one, that we didn't make the argument in our opening brief?
Yeah, I don't see where you ever argued that they were a public forum or and explained how they were a public forum.
So, Your Honor, I believe that we did, yes. On page 15, the traditionally publicly accessible portions of the Capitol grounds are a public forum, and the government failed to meet its burden of showing otherwise. And we specifically mentioned the Capitol
Okay, yeah,
Rotunda.
I misspoke. I guess my point is that you didn't argue it below, right?
Correct, Your Honor, and that's...
And you didn't seek to present any evidence or make any record on that point below. Am I right about that?
That's correct, Your Honor.
Okay.
And the reason why is because, so one is the government's burden. So
Why is it the government's burden? We presume the statute is unconstitutional. You have the burden of showing that it's either vague or overbroad. So wouldn't part of that burden be to show that it's a public forum rather than a non-public forum?
Your Honor, this circuit, this court said in Laterman that the government bears the burden of showing, one, that it's a public or non-public forum, and two, the tailoring or the reasonable relationship. And the government
On
has
the motion
conceded-
to dismiss, where the government has the burden of establishing that it's entitled to a motion to dismiss, right?
Your Honor, respectfully, no, the Laterman case wasn't talking about the burden on a motion to dismiss. They were talking about the burden in the forum analysis, which the government has conceded that it does bear the burden of proving the Constitution.
All right, but it was in the context of the government making a motion to dismiss in a civil case.
That's correct. However, there...
Or perhaps more specific to Lederman, where it's a traditional public forum rather than a limited or designated public forum, that's established. And if there's some restriction on that, a particular part of sidewalk or street, then it's the government's burden. But my understanding is that it's always been the plaintiff's burden, at least to come forward with a reason to think that a designated or limited public forum is in fact so designated or so limited. And it may be by tradition or custom, it may be by specific declaration, but there has to be some reason that the person who's subject to the law believes that it's been opened. So I actually think, I'd be interested in any precedent or authority that you have on that, but my understanding of the case is that it is actually the burden of the member of the public who's subject to the law in that context.
Your Honor, we haven't seen any authority saying that, and the government hasn't cited any. So I can't speak to that, but I can say that the Supreme Court has held that when the government restricts speech, it bears the burden of proving the constitutionality of its actions. That's United States versus Playboy Entertainment Group. So, but regardless of who bears the burden, The reason the forum analysis was not addressed below is because frankly, we don't think that is the appropriate analysis at all. We don't think that that's necessary to reach under the overbreadth analysis, which we recognize that we do bear the burden. The government did not address directly the forum analysis either, other than some brief cites to cases that mentioned it. It was not something that was at issue at the motion to dismiss stage below.
So are you saying that you're willing to rest your case on the assumption that it's not a designated or limited public forum, but that it's a non-public forum, but in your view, it is still a constitutional violation?
So, Your Honor, we would not concede that it's not a public, we think there are large portions of it that do meet the public forum standard. They're publicly accessible. They were traditionally designed as a meeting place like the rotunda. They were historically used as those things, and people have been allowed to express themselves. However, yes, even in a non-public forum, we believe that it's unconstitutional because it's not reasonably related to the purpose of the forum, which is legislating and representing the interests of the people of the United States.
You said that at least some portions were historically used for public gathering and discussion. Is there evidence of that in the record?
Not in the record, Your Honor, because again, it did not come up below the government. Neither we nor the government argued it was about overbreadth until the district court made that decision. However, we would be happy to provide supplemental briefing on that matter if the court decides. I think certain things, the court could certainly take judicial notice of, such as the fact that the rotunda was designed to be a public meeting place that, is just kind of historical information about the Capitol that we think the court could take judicial notice of.
Can I ask a methodological question about, you mentioned how the forum analysis and overbreadth interrelate. And one view is that under the overbreadth doctrine, it's your burden to come forward and show that a substantial number of applications are unconstitutional, right? And then how can we answer whether any application is unconstitutional without doing the forum analysis?
Yes.
Aren't they inextricably connected here?
Yes, Your Honor, this is a very good question. And, we exhaustively searched the case law for a good answer on this. And unfortunately, I don't think there is one. There are cases that go straight overbreadth. There are cases that incorporate the public forum analysis into the overbreadth analysis. And it's further confusing because there are cases that say the government bears the burden on the forum analysis, but yet we bear the burden on overbreadth. Still, I think most of the time, probably all the time, they have the same answer. I think whether you're asking whether it's overbroad because it shows substantial amount of speech or whether it's reasonable in light of the purpose served by the forum, I think those answers are pretty much always going to be the same. So I don't know that the relationship has an impact on the decision. But unfortunately, I don't think the case law provides a good answer for what exactly that interrelationship is. We'll also say that I think here in a facial challenge, the forum analysis is very clumsy because we have all of these the Capitol buildings that's a broad location. We have many different locations. And in a facial challenge, we can't ask what specific portion we're talking about. And the public forum analysis kind of demands that we do. So when you have this broad location with all these different forums, it makes that analysis unclear. If you find that one part is a public forum, do you apply that analysis? Do you apply a non-public forum analysis? So that's a long explanation.
I have a question just going to your sentencing argument. I believe that there was a chart that you submitted to Judge Bates as part of your sentencing argument comparing different cases in support of the argument that there was a penalty for going to trial. I don't think that that's in the record.
Your Honor, we could certainly provide the court with that if it would like.
In terms of the nature of the cases included on the chart, I don't know if you know this standing here, but did the guilty plea comparator cases have the same calculated guideline range as the range calculated for Mr. Is it Nassif or Nassif?
Mr. Nassif, Your Honor, and standing here, I don't want to say one way or the other. I'm not totally sure, but we can certainly provide the court with supplemental briefing on that if that's important to the court.
I have a question about your vagueness argument. My understanding is that your arguments below and here are essentially facial challenges to the statute. They're about the outer limits of what it covers and not about Mr. Nassif's conduct in particular in this case. Is that right?
Yes, Your Honor. They're both facial challenges.
Okay. And so I realize the government didn't cite this case, and this will be a question I have for them. But the Supreme Court held in a case called Holder versus Humanitarian Law Project that someone whose conduct is clearly prescribed cannot complain of the vagueness of the laws applied to the conduct of others. And that's just a basic application of the general principle that you don't get to rely on the rights of others. And I'm just curious if you, again, realizing it wasn't cited in the briefs, if you have a response to why that doesn't foreclose your vagueness claim here.
Yes, Your Honor. There are a couple of reasons. One, there's some question after DeMaya and Johnson, which Johnson was cited in our brief, whether that still applies. There's some circuit court cases that say that it was dicta. The other thing is that this circuit has made clear that Holder versus Humanitarian Law Project is not controlling whenever we're talking about anything other than fair notice. So if fair notice is at issue, then there's a question of, well, can one person who did have fair notice complain about fair notice as applied to others? However, in the First Amendment context, whenever you're dealing with chilling effect as it relates to vagueness, or whenever you're dealing with arbitrary enforcement, which is our primary position here, that Holder versus Humanitarian Law Project language would not apply here, would not adjust.
Okay, so that's the Act Now case. That case involved a pre-enforcement challenge, and it explained essentially you can't really conceive of an as-applied standardless enforcement challenge in the context of a pre-enforcement challenge. But you can very much conceive of what that would look like here, right? Mr. Nassif would say, it is so unclear whether my conduct was a demonstration that I was subject to the discretionary whims of the government. And that argument would be the sort of as applied analogy to what Holder seems to require. And I'm just troubled by the fact it doesn't seem like we have that kind of argument here.
Yes, Your Honor. So although the Act Now case was a pre-enforcement challenge, what really I think the reasoning is getting at is that it's fundamentally different to talk about fair notice and arbitrary enforcement. And that's especially true in the First Amendment context, because the main concern there is that it's going to have a chilling effect on others. And here, where you have the government just shifting its position at almost every turn, I mean, at every stage in this case, they have changed it to something different. And where you have the Capitol Police having these vague, broad definitions that they kind of turn on a dime when they need to, that, is just manifestly arbitrary. And it certainly would lead to a chilling effect and arbitrary enforcement. So I think, even though I do understand Your Honor's concern about it not being an as-applied concern here, I think that the reasoning in the Act Now case, and I think also in DC District Court case, United States versus McGee, I don't know if I'm pronouncing that right, I think it was Judge Pillard's opinion.
So, Ms. Fussell, we will give you some time for rebuttal.
Thank you, Your Honor.
Morning, Mr. Cahill.
Good morning, Your Honors. I proceed. Timothy Cahill for the United States. May it please the court. Just like to begin by addressing and rebutting a point that came up repeatedly during appellant's argument, this idea that the government has made inconsistent representations on its position. We admit that that simply isn't supported by the records in the cases below. I would point out that in the Ballinger case, which was cited multiple times, the dispute was about whether or not conduct had to be, quote, loud or destructive in order to violate the statute. And the government's position was that it was not. That is not inconsistent with the position we've taken here or elsewhere. And many of the other claims of inconsistencies are based on conflating what we submit are two completely discrete types of elements. Well, one is the prospective question of the nature of conduct, whether or not it is of the nature to tend to disrupt. The second is a retrospective question, whether it requires proof of an actual disruption. I would note that one of the statutes that Mr. Nassif was convicted of, 1752A2, requires proof of both of those things. The 5104 misdemeanor statutes do not. And so a lot of the claims of inconsistency are based on cherry picking statements that relate to different elements in different statutes. I wanted to clear that up before moving on to some of the other arguments.
How does the government understand the meaning of disrupt, just as a matter of statutory text in context?
So, to clarify, Your Honor,
I'm sorry, not disrupt, demonstrate. I'm sorry, I misspoke.
So certainly, Your Honor. So we believe that both the text of this statute and the legislative history support reading demonstrate in this statute as referring to demonstrations that would tend to disrupt the orderly business of Congress. And we would point to the Bronstein case. I recognize that that was a vagueness challenge, but in terms of statutory interpretation, it's highly instructive here. It involved the question of the meaning of the word oration and also the word harangue in the context of the Supreme Court's buildings and grounds. And this court looked in the text, just like doing a statutory interpretation, to three sources. One were the surrounding statutory terms, which here in the actual provision at issue include parading and picketing, which informs what demonstrate means. And it also is relevant that in the surrounding provisions, there's prohibitions on loud, threatening, or abusive language. I would note that that exact phrase was also present in the statute at issue in Bronstein, and this court pointed to it as evidence that the statute was concerned with disruptive conduct. In Bronstein, this court also looked at the title of the statute as informing the context. Here, the title of the statute is violent entry and disorderly conduct. It looked at the limit, I'm sorry, Your Honor. Oh, I thought you were about to speak, I apologize. It also looked at the limited location where the statute applied, in that case, just the Supreme Court's buildings and grounds, here, just the interiors of the Capitol buildings. So for all of those reasons, just applying ordinary principles of statutory interpretation, we believe that that would be the proper way to interpret the scope of the statute.
So what would be the operative facts that would allow a member of the public to know that something is a demonstration that tends to disrupt? Is it noise level? Is it size of the group? Is it something else? If I want to go with 4 friends and hold a quiet vigil standing to the side of any business being conducted, passing through the rotunda, is that a demonstration that's prohibited or not?
So I would submit that on its face, that would appear not to be prohibited, but it's all very context dependent. If that was happening in the doorway of a congressperson's office, maybe it would be. But that's a factually specific question that in the first instance could be determined by a judge or a jury. I would note that in the 5104 cases that have gone to jury trials, the government has proposed and oftentimes jointly proposed with the defense jury instructions that have defined the term demonstrate in just this way. And in any statute, at its margins, there's going to be factual determinations as to whether or not the terms of that statute apply. And if there are particular cases or particular circumstances where a conviction raises concerns about whether it's going too far to infringe on constitutional rights, that's where as applied challenges come in.
But we also have a notice problem, or at least a question raised about it. And so what is the difference between conduct that would tend to disrupt and conduct that disrupts? And I understand that, as you said, conceptually, one is a prospective assessment, but if I'm someone who wants to decide whether my planned action is covered, how am I supposed to know what tends to disrupt? Especially if I've not spent a lot of time in the Capitol.
Understood, Your Honor. So, I mean, I would point in that context to this court's similar assessment of a very similar question in Bronstein. And in Bronstein, the court determined that it was determinable conduct because even though—
An oration or a harangue in the chamber of the Supreme Court is so much clearer, in my view, than what you're presenting here.
I don't think so, Your Honor, not in the sense of the key interpretive principle that the court applied in Bronstein, and the key phrase that the court applied in Bronstein was to tend to disrupt the court's operations. So if the question is what would tend to disrupt the court's operations, I think that is susceptible to the same sort of notice and provides the same sort of notice, especially given that the case law is clear that when considering vagueness challenges, it's not an unconstitutional infirmity to have an imprecise standard that might be applied differently by reasonable jurists, that might even be applied differently by reasonable fact finders. It's only susceptible or it's only infirm constitutionally for vagueness if there's no standard at all. And that isn't the case here.
So is there an understanding of the term demonstrate within the statute that doesn't depend?
Statutory interpretive principles, just as this court applied in Brunstein, based upon surrounding terms, title, and even in this case, if the court finds it ambiguous, looking to the legislative history.
Well, I think, counsel, just on that, another interpretive principle is that when Congress uses a word in one place but not another, we won't read it in. And it strikes me that you're essentially saying that this should be read to say parade, picket, or disorderly demonstrate. That's how you get to tend to disrupt, correct?
I don't think so, Your Honor, just because disorderly conduct is a longstanding legal term of art. And so, for instance, it's used in subsection D to refer to a broader category of disorderly conduct. We are reading the word demonstrate in this context, in the context of a statute that in all of its subprovisions describes types of disorderly conduct, even within the same subprovision, describes inherently types of disorderly conduct like picketing and parading, as reading the term demonstrate to be akin to the types of conduct that are prohibited within the same subprovision and within the preceding subprovision.
I take it the government would not embrace a reading of the statute that understood demonstrate as presenting oneself in a place for the purpose of expressing support or disapproval of an identified action or viewpoint. In other words, another reason to be in the Capitol that is not, to visit or meet or tour or otherwise, but.
We would submit that the statute does not encompass that broad a definition of demonstrate. That's our interpretation of the statute.
That seems broader to you.
Then a demonstration that would tend to disrupt the orderly business of Congress, I would say so, yes.
I guess a related question is the conduct at issue in Bynum was a group that was undertaking prayer in the Capitol, and they were advised that even silent prayer in statutory hall was not permitted because that was a demonstration. Is that the correct interpretation of the statute of this subsection?
The court's reading in Bynum?
No, if that's what the Capitol police officer told Reverend Bynum and his group, is that a correct interpretation of 5104 E2G?
So, Your Honor, at this point, I would say no. I mean, the government in this case is embracing Judge Friedman's description of the scope of that statute in Bynum, which he found to be constitutionally sound. What Judge Friedman objected to was the Capitol Police regulation that encompassed the silent prayer. And I would note, Your Honor, I know that in the briefing, appellants have relied on current Capitol regulations to argue that they haven't changed. But I would point out that the part of the Capitol regulations that have been cited are actually regulations concerning demonstration activity that is permitted on the grounds. If you look further in the same Capitol Police regulations, I think page A59, it actually describes the Bynum decision describes the holding of the Bynum decision and advises that demonstrations inside the Capitol don't violate this statute unless they're disruptive. So if we're looking at the Capitol Police regulations as informing the plausibility of certain hypotheticals and the likelihood of enforcement, it actually cuts against appellants.
Counsel,
Unless they're disruptive or tend to disrupt.
I think it just uses the word disruptive. I would point that in Judge Bynum's decision, in Judge Friedman's decision in Bynum, he uses the phrase would disrupt. He phrases it as a prospective test, which is the same phrasing that this court used. And again, we would submit an analogous context in Bronstein. It's referred to tending to disrupt, threatening to disrupt. That is historically how, for instance, Black's Law Dictionary defines disorderly conduct as tending to violate, to disturb the peace.
That's helpful. I had understood Ms. Fussell to make an argument that the government's interest in the anti-parading, picketing, and demonstrating statute is sort of impugned by the fact that the disruption statute only applies when Congress is in session. What do we make of that? So this applies when Congress is not in session?
Yes, Your Honor.
Is that reasonable?
It's reasonable, Your Honor, because of the other specific narrowing features of this provision as compared to subsection D, which is the broader disorderly and disruptive conduct provision. This provision only applies inside the Capitol building, within the actual building, and also only applies to the particular types of identified disruptive conduct. And as in related cases, the District of Columbia Court of Appeals has recognized and would submit as just a matter of common sense, even when Congress is not holding a specific proceeding or a specific hearing, there is business of Congress being conducted inside the building, inside the offices of Congress people who are meeting with staffers, meeting with other Congress people, having discussions. And that's why this statute is specific to inside the Capitol building. The broader provision that applies all the way in the exterior grounds requires a higher showing. It requires an intent even to disrupt an active proceeding of Congress, an active session, an active meeting, an active hearing. And
Counsel, we've understandably focused on the statutory interpretation question, but I understood your brief to argue that we actually don't need to resolve the statutory interpretation issue in this case, at least to resolve the First Amendment question. Is that right? That's the government's position?
That's correct. And I understand logically and logistically, oftentimes that's the first step in this analysis, but we would submit it's not ultimately necessary. And if the court agrees, then it could affirm simply by saying that under either interpretation, the statute passes constitutional muster.
And then just briefly on the vagueness issue, I raised the Holder case. Does the government have a position on whether that bars the claim here?
I mean, we haven't briefed that case, Your Honor, so I wouldn't be relying on it here. I would point that we did in our brief. I know it is not an identical concept, but I would say it touches on some of the same concerns. We did cite Hill v. Colorado for the principle that speculation about possible vagueness in hypothetical situations before the court will not support a facial attack on a statute when it is clearly valid in the majority of its intended applications. And I recognize that's not an identical principle, but we would submit that on that ground as well. For somewhat analogous reasons, the vagueness challenge here should fail. For those reasons and for the reasons outlined in our brief, especially with respect to the sentencing claims as well, we would ask that the court affirm the judgment of the district court. I'm sorry, Your Honor.
I'm sorry, I wanted to ask you if you had a view on the burden on the forum.
So, Your Honor,
Where it's a designated or limited.
The broader point that the government has to support a restriction on speech as constitutional is what the government didn't contest. This idea that there's an evidentiary burden on forum, we did dispute in our brief. And in Lederman, it makes very clear that the court's reference to some sort of evidentiary burden is because the very specific forum at issue there was a sidewalk. And the court held that there's a strong presumption that a sidewalk is a public forum unless the government has proven otherwise, that there's some specialized use for that sidewalk. There was no indication that that applies elsewhere.
Right. So my reading of cases like Stewart versus DC Armory, which wasn't cited in the briefing, 863 F. 2nd, 1013, is that the forum doctrine the limited public forum doctrine involves a factual inquiry, and that in that case, we thought that inquiry needed to be delved into, and that would be the burden on the challenger of the law. Do you have any reason to think that's not the right?
I have no
analysis?
reason to think that that is inaccurate, Your Honor, no.
Thank you.
With that, if there are no further questions, thank you, Your Honor.
Ms. Fussell, we'll give you 2 minutes for rebuttal.
Thank you, Your Honors. I know there's been some question about burden and forum, but I want to reiterate again that our position is that Congress directly targeted and criminalized First Amendment speech in the publicly accessible buildings that make up our seat of government. And we say that that is unconstitutional, regardless of the analysis that applies. I want to address the fact that the government indicated that its positions have been consistent. We ask the court to look again at the Ballinger case. It is extremely an important point, I think, here, because when the government is opposing a motion for acquittal or there's a dispute as to sufficiency of the evidence, they say, no, 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 this doesn't mean disruptive conduct. Even showing up is enough. We don't have to show anything like that. And then when the validity of the statute hangs in the balance, the government says, oh, well, of course, disruptive conduct is required, or conduct that would tend to disrupt, which I don't know if the court understands the difference between those after the government's argument, but I certainly don't. Now, as the government pointed out, I think the only way to evaluate their standard is that it's that this context-specific standard is with a lot of discretion on the part of the Capitol Police officers. And this isn't in the briefs because this is the first time that the government has indicated that the Capitol Police wouldn't enforce their regulation as written. And they brought up the fact that Bynum was mentioned. And it was in the Capitol Police regulations in a summary of constitutional challenges at the end. But this past June, the Capitol Police stopped a group of children from singing the national anthem in the Capitol building, telling them their song, which was invited by a member of Congress, was a prohibited demonstration. To quote the Capitol Police's official statement on the matter, here is the truth. Demonstrations are not allowed in the U.S. Capitol. I submit that respectfully that whatever instruction the government, has really advanced today, that's the truth. Demonstrations are not allowed in the U.S. Capitol, no matter how peaceful, quiet, or vital to our self-government they are. If there are no
Thank
questions.
you, Ms. Fussell. The case is submitted.
Thank you, Your Honor.
Take a brief recess. Stand, please. This honorable court is now back in session. Case number 22-5281, American Oversight Appellant versus United States Department of Health and Human Services and Office of Management and Budget. Ms. Morton for appellant, Mr. Schultz for appellees.
Morning, Ms. Morton. You may proceed when you're ready.
Good morning, Your Honors, and may it please the court. Jessica Morton for Plaintiff Appellant American Oversight. I've asked to reserve 2 minutes for rebuttal. In Klamath, the Supreme Court identified the contours of a typical consultant relationship, which might fulfill the consultant corollary. One where the purported consultant acts just as an employee would be expected to do, and so can be fairly deemed part of the agency itself. The record in this case is replete with evidence that the members of Congress and their staff communicating with HHS and OMB were not acting just as employees of those agencies. I turned to the Slimrod Declaration, Mr. Slimrod from OMB. At JA 109, he discusses negotiating legislative compromises. At JA 111, he discusses capitalizing on opportunities to influence the drafting process that comports with administration policies. At JA 113, he mentions emails including discussions of, quote, sources of ongoing disagreement, end quote, between the administration and Congress. Again at 113, providing technical assistance to Congress in drafting. At JA 115, he writes, and I quote, OMB sought to influence and shape pending legislation by discussing, consulting, and negotiating with congressional personnel regarding the details of legislative proposals and the legislative process. And at JA 116, he expresses concern about chilling OMB's negotiations with Congress.
Can I ask you about EPA v. Mink? You don't think that Klamath overruled EPA v. Mink, do you?
I beg your pardon, Your Honor, I'm sorry.
You don't believe that the Klamath decision overruled the court's earlier decision in EPA Mink, do you?
I don't believe so, Your Honor.
So in EPA v. Mink, there was a task force group, don't know the specific title for it, that was created to advise the president with respect to nuclear testing that was planned. The court said that is not an agency with respect to FOIA. And so the question in the case was, well, were documents that were transmitted between the EPA, which is an agency under FOIA, and this group, which was not an agency under FOIA, are those either interagency or intra-agency communications? And the court disposed of that argument very easily and said, obviously they are. It didn't really matter that EPA, the agency, was communicating with a non-agency. That was notwithstanding this consultant corollary doctrine. It was all seems to be part of the court's understanding that whatever this non-agency was doing, communicating with the agency, it was all part and parcel of actions that were part of the deliberations that were going to be advising the president. Do you think that's a fair characterization of the holding on that issue in EPA v. Mink?
As I recall it, Your Honor.
Given that, why isn't it, and the rationale of EPA v. Mink was cited by us after Klamath in the Judicial Watch v. I think it's Department of Energy case in 2005, which also involved like a task force that was a non-agency that was sending documents back and forth with an agency. So I guess what I'm saying is, even outside of this consultant corollary doctrine, there's been an understanding from the beginning of FOIA that the interagency, intra-agency test is not literal, in that it can include within that set for exemption 5, documents that go back and forth between an agency and a non-agency, if they are part of kind of the process of deliberations within the executive branch.
I would cling on to that last point that you made, Your Honor, deliberations within the executive branch. It's my understanding that in both EPA, Mink, and Judicial Watch, these are bodies set up to advise the president within the judicial branch, that the courts found this particularly important to their holdings. Here, of course, Congress is not an advisory council to the president in the executive branch. Congress is a separate co-equal branch of government.
But
And
the pushback I would have is that if the president wants to pass legislation, the president can draft all the legislation as much as he likes, but he has to get a member of Congress to introduce the legislation. He can't directly introduce the legislation. And likewise, the president needs to know what Congress will pass. And so that influences his deliberations as to what to propose in the deliberations. And Congress wants to know what the president might veto or not, so that they can decide what they're going to do. And in turn, they communicate essentially to get the advice of the president. But all of this is being done in context of advising the president about either what to do about legislation that's about to be introduced or what to do about legislation that has been introduced.
well, Your Honor, I certainly agree that both Congress and the president have interest in knowing what their co-branches are doing on these kinds of issues. But I would disagree when it comes to the idea that they're advising the president in the same way that the Advisory Council and Judicial Watch is advising the president. Because Congress, as you articulated, has its own interest in knowing what the president is going to do, its own interest in passing legislation, its own interest in what kind of bill is put forward. Of course, Congress certainly wants to know if the president is going to support the bill or not, but that's why this is really, as the document that I cited from Mr. Slimrod shows, a two-way street where there is advice being given both ways. And
Is it fair to say that Congress is giving information to OMB or HHS that will be used to advise the president?
Your Honor, it is certainly the case that Mr. Slimrod in his declaration said that some of the information received was being used by OMB to prepare recommendations as to whether the president should support a bill in his SAP. But it is also the case that Congress is receiving information from the executive branch, that OMB is providing technical assistance to Congress, and that this is not simply a case of soliciting the executive branch soliciting information from an advisory committee in a one-way street, the way an employee would be expected to do for its employer. This is a negotiation between co-equal branches, which is consistent with our separation of powers principles.
What is the difference between the senators in Ryan versus Department of Justice and the members and their staffers in this case? Doesn't Ryan stand for the proposition that as long as the agency reaches out to legislators for advice or input, then the communications are intra-agency communications?
Well, first of all, Your Honor, solicitation on its own can no longer stand after Klamath because there was solicitation there, which the court found insufficient. But
Is
Ryan,
it needed even if it's not sufficient? Necessary?
I believe so, Your Honor. But Ryan is also distinguishable on its facts. In that case, the Attorney General asked every senator, not just some as the case was here, to answer specific questions about the process that they were using to recommend nominees for federal district court judges. And this has resulted in a one-way flow of largely factual and procedural information back. The questions in Ryan, which are available at 617 F2D 791, ask things like the demographics of the nominating committee, how they chose who to interview, how many people they interviewed. And there's no indication in that the answers to those questions could reflect any sort of self-interest on the part of the respondents. That's quite different than the facts we have here, where there's a complex legislation on the table, and we see evidence in the record that the executive branch and the legislative branch are going back and forth and, quote, negotiating over what should be in these bills going forward.
What I can't understand in the big picture here is that Congress exempted itself from FOIA, right?
Yes, Your Honor.
So your position is that Congress, whose deliberations and communications aren't discoverable under FOIA, the minute that they communicate with the executive branch, they become discoverable under FOIA because unless we can say that their interests were completely aligned, or you would say that the alignment of interests is irrelevant. I'm trying to understand your position.
I would say that the test from Klamath and articulated again in Peer is the test of whether or not the purported consultant is behaving just as an employee would be expected to do and has no interest of its own or anyone else. But to your textual point, Your Honor, it's certainly the case that Congress knew how to exempt itself from FOIA and chose not to exempt itself from the term, chose to exempt itself from the term agency, and it could have written Exemption 5 in a way that would protect its communications and chose not to. And this court's precedent, the Supreme Court precedent, is clear that when Congress makes an intentional choice to exempt itself in one place but not elsewhere, we should give respect to that decision.
So relatedly, I'm curious about this. There's not a lot of precedent on this, but there's a lot of interaction between the executive branch and Congress on legislation all the time. And so do you have a sense of whether agencies routinely withhold congressional communications from FOIA requests under Exemption 5, or are they typically not asked? Is this a new phenomenon? Why isn't there more of an established understanding on this? Or is there, and I'm just not aware of it?
I don't have any metrics, Your Honor. I do know that I'm only familiar with 4 cases, all from district within this court, that affirmatively address this issue of communications between Congress and the executive branch regarding legislation in a meaningful way. It's my understanding that the executive branch does sometimes not enforce Exemption 5 of these communications and sometimes will disclose documents. In this case, at J125-26, we discuss documents that were not withheld in this case.
In this case. Mm-hmm.
But it's my understanding that in other cases as well, the executive branch has not always chosen to withhold those documents. But I'm not aware, Your Honor, of how frequently they're requested or how frequently the department chooses one action over another.
But I guess Judge Pillard's question gets to a concern that I have, which quite frankly is like, how is the legislative process, which already doesn't work so well, how is that supposed to work when the communications between the Congress and the executive branch would be in a fishbowl, if you're right?
Well, first, Your
How does
Honor,
that advance kind of our understanding of kind of the delicate balance that FOIA was intended to keep and maintain?
as you point out, Your Honor, there is a delicate balance in FOIA between enabling agencies to make the best decisions possible through having expert, independent advice that is unbiased and providing transparency and sunshine to the public. And that's why in the typical consultant corollary case where you have this unbiased interest, it's appropriate to permit consultant communications to be withheld. But whenever, under the test in Klamath and Peer, you have self-interested outside purported consultants, that's when that policy interest becomes a bit diminished because it's no longer about a true intra-agency determination, but about outside consultants influencing that decision. And that's when sunshine and transparency become all the more important.
I guess the reason that I have trouble feeling that like that's the only prism in which we should look at this, is that, you know, in a lot of ways, this is like a settlement negotiation occurring between Congress and the president. And settlement negotiations are also, you know, confidential. And it doesn't, the parties that are settling don't have aligned interests. Normally their interests are absolutely conflicting. But when the first party says to the other party, you know, this is my offer, and if you don't take this offer, I'm going to beat you over the head with, you know, this evidence, or sue you in another case, or whatever it is, they're advising the other side. It may be from their own interests, but it's advice that the other side is taking, and they are using that to determine kind of what to do and whether to accept the offer or whether to make a counter offer and what that should be. So I guess I'm not sure that I agree with the premise that just because it's a different branch and their interests may not perfectly be aligned, that it's still not akin to the same sort of interest that FOIA is trying to protect. What's your response to that when looking at it?
2 points, Your Honor. First, you know, I appreciate the point that you're making, but that's simply not the test respectfully set out in Peer, which says that where an outside consultant does not have its own interest in mind is the moment consultant corollary is appropriate.
But my point is that the consultant corollary doctrine isn't the only way of looking at how to determine whether there's an interagency communication. EPA v. Mink didn't use the words consultant corollary. Those words hadn't even been invented yet.
Correct, Your Honor, but this court in the wake of Klamath has interpreted the consultant corollary to be the appropriate mode of understanding whether a document is intra-agency or interagency under the text of FOIA Exemption 5. I also wanted to point out in response to your question, Your Honor, about the concerns of chilling interactions between the branches. You know, in Klamath itself, the Supreme Court recognized that the declarations put forward clearly stated that there was a concern that communications would be chilled. And they credited those declarations and said, even if that's the case, that simply can't carry the day here.
Let me ask you, Ms. Morton, at least some of these communications involved HHS or OMB soliciting specific updates on bill text or the status of bills from Congress. And I wonder whether we need to sort of separate out the various different communications here and analyze some of them per Ryan separately from the rest. If the executive is using the congressional members and staff in 2 different ways, on the one hand saying, we just need to know where this state of play is. And in that sense, it's just information versus a bunch of kind of negotiating back and forth where the Congress members are in their advocacy role and they've certainly got their constituents to represent. Should we sort of sift through the communications and hold that some are subject to the consultant corollary and some not?
Well, Your Honor, you're certainly correct that there's a spectrum of types of communications and that the ones that are negotiations are the most problematic. But I would remind the court that the government bears the burden of showing that consultant corollary does not apply, that the exemption 5 does not apply and the consultant corollary does. And so we only have what's before us on this record here. I would also point out that in Ryan, as opposed to what we have here, the AG submitted the questionnaire to every senator, whereas here we only have communications with a small number of members of Congress and their staff.
And it is very odd. I mean, it seems like the government's reasoning is that the interests are aligned, and they actually have two different versions of that. One is everybody takes an oath to uphold the Constitution, but the other is that they wanted the same thing on the healthcare bill. To the extent that it's the latter, it seems that the argument is that the consultant corollary applies here, but it wouldn't apply if the HHS or OMB personnel had reached out to people who were defending the existing healthcare law, people on the Hill who are defending the existing healthcare law. Is that how you understand it, or why isn't it enough that everybody takes the same oath of allegiance to the Constitution?
That is how I understand the government's position, Judge Pillard. I think that's why it's difficult to apply, because it suggests that everyone shares a same goal at a very high level, but so attenuated as to be difficult to apply in context, because people may agree that they want to repeal and replace the Affordable Care Act, but disagree about how to actually do so or how to implement it. Or they may agree on the broad brushstrokes, but have very different views on what particular provision should be included or not, if one is a particular interest to their constituents. Party lines are not clear or easy way to draw this. There's a statement in the record and in the crew brief at 11 from Republican Congressman Whitman, who said that he opposed the bill because of, quote, the best interest of Virginians, thinking about his constituents. That's in the record at docket 30-3 at 97.
I have a question about this, because when there were cross motions for summary judgment, and one of the facts that the government said was undisputed was that HHS and members of Congress and their staff who exchanged the emails at issue in this case shared a common interest in enacting healthcare reform legislation. That was their statement of fact number 15. And they had a declaration from Krasecki as evidence of that. Your client denied that, but did not cite any evidence in the denial, just said, see our points of authority. Under our district court's local rule, that's not sufficient to counter the statement of fact in a summary judgment motion. The district court found that there was a common interest. That's in the memorandum of opinion. Don't we review that for clear error? And can't we say that really it's kind of like too little, too late for you to dispute that fact now when you didn't really dispute it in the district court?
A few points in response, Your Honor. First of all, at the summary judgment standard with de novo review, I'm not sure I would qualify this as a factual finding, because at summary judgment, a district court should be not making specific factual findings, but instead treating the facts in the light most favorable to the party opposing.
Well, the district court has to determine whether a fact is in dispute to know whether it can decide the case or whether it needs to have a trial or some sort of a hearing to make a finding on a disputed fact. And here, that's why you file your statement of facts which you contend aren't in dispute, so that the district court can sort it out and see, can I decide this case on summary judgment or not?
Your Honor, even accepting the statement that the members of Congress who were communicating with the executive branch and those executive branch agencies shared an interest in healthcare reform, that still doesn't allow for an administrable rule going forward because of the complex details of legislation, as evidenced by points of disagreement and negotiations that are shown in the record. I also wanted to address, in response to both that question and Judge Pillar's question, that the real question in Klamath is not necessarily the identity between the purported consultant and the agency, but whether there is a lack of identity of interest between the purported consultant and their compatriots. So in Klamath, there's a lack of identity of interest between the tribes and other claimants to water. And so too here, the members of Congress with whom OMB and HHS consulted may share their interest in overturning the Affordable Care Act, but there are other members of Congress who do not share that interest, and they are not able to get into the bill the provisions that they want to have necessarily, or that they are hoping that the bill is vetoed while the members of Congress who are working with the agencies hope that it is signed. And it's that difference that is material. Your Honor, I'm sorry.
I apologize. I just want to clarify what exactly you think the test is. I understood you earlier to be saying that we should basically adopt as a rule what Klamath described as the typical case. And so whether there's a common interest at whatever level of generality is irrelevant under your view. Is that right?
I believe that this court should adopt the test in Klamath and articulate it in Peer, which is that the consultant corollary is confined to situations where an outside consultant did not have its own interest in mind and is so behaving just as an employee would be expected to do. I realize I'm far over time, but with the court's indulgence, I would like to speak to the adequacy of the search unless the court would prefer that I not.
I just had one question about that. Why isn't it enough that HHS states that any potentially responsive records, whether they be emails or calendar entries, would contain one or more of these search terms? That's from the Bell Declaration, paragraph 17.
Yes, Your Honor. So of course, the declarations are afforded a presumption of good faith. That doesn't mean that they are infallible. And if you turn to the page before JA 122 at paragraph 16, Mr. Bell describes that they searched only the terms that were frequently used as opposed to more general terms. And so the declaration doesn't speak to whether terms be requested, such as Obamacare, which are commonly used synonyms for the Affordable Care Act, would have produced additional documents. The standard in this court is the agency has to demonstrate beyond material doubt that it's undertaken a search reasonably calculated to uncover all relevant documents. The declaration doesn't do that, but even more than that, here, we put forward evidence in the record that leaders in HHS and Congress were using the term Obamacare. So at JA 470, there's a document produced by HHS in which the Senate Finance Committee describes Senator Orrin Hatch's position on Obamacare. At JA 476 is a quote from HHS to the press that manages to use Obamacare 3 times in 2 sentences. There are several sites in the record to transcripts from television segments at 358, 69, 415, 428, and 429, where Secretary Tom Price is using the term. And so
But do any of those citations, instances, they used Obamacare, but they did not use one of the search terms?
Well, Your Honor, as to the documents produced by HHS, it would be impossible for us to have any documents that did not include the search terms that were already used. Your Honor, I'm sorry.
I might have misheard you, but I thought you said that Obamacare was one of your requested search terms.
I apologize. It was a search term that we request that HHS would include. We did not provide HHS with requested search terms in our original FOIA request.
Can you clarify when you asked them to include that term?
It was in negotiations that I believe were in the spring of 2017.
Before they prepared these declarations?
I would have to confirm the exact timeline, Your Honor.
While the case was pending in the district court.
I believe so. So we're having. Thank you, Your Honors.
We'll give you a couple of minutes for rebuttal.
Thank you, Your Honor.
Morning, Mr. Schultz.
Morning, Your Honor. May it please the court, Benjamin Schultz on behalf of the government. I'll start with the consultant corollary. And I think my colleague's colloquy with Judge Garcia really encapsulates the problem with this case, which is that the position they want this court to adopt, that a consultant can never be self-interested, is a position that this court has already rejected in its case law. And in Klamath, the Supreme Court specifically acknowledged that. It had a footnote where it talked about this court's opinion in Ryan and this court's in Public Citizen. The Supreme Court said that the consultants in those cases would be expected to have strong interests of their own. And the Supreme Court said it was not overruling those cases. This court, post-Klamath,
Said it had no occasion to determine whether to overrule.
That's right. I mean, we're not saying that, there might be some future case where we get more guidance from the Supreme Court about what the consultant corollary is, but certainly Klamath on its own did not overrule those cases, and they remain the binding case law of the circuit. And not only do we know that from Klamath, but we also know it because after Klamath, this court made exactly that point. And in the NIMJ case.
Counsel, in NIMJ, I agree at one point it does say something to that effect. Then later, it explicitly carves out this question again and notes that the entity at issue in that case did not have its own interest in mind. And then we make exactly the same statement in Peer and in our other cases since then.
So I think Your Honor is right that there has not been a post-Klamath case that this court has decided where this court then said the consultant was self-interested and we are applying the consultant corollary anyway. But what
Go ahead. I didn't mean to interrupt you. We're here to hear from you.
Sure, but I think we do know that Ryan and Public Citizen are cases where the consultant was self-interested, and those remain binding case law in this court.
But I actually think that's a little bit of a sort of blurring over the distinction. In Ryan, the presidents probably had strong feelings, but the information that they were being asked and the interaction was not one that was affected by those feelings. They were asking for, pretty straightforward information. And indeed, in NIMJ, we said that the court in Klamath explained the fact about the consultant, this is on page 682, the fact about the consultant that is constant in the typical cases is the consultant does not represent an interest of its own or the interest of any other client when it advises the agency that hires it. So the nuclear scientists in Mink, clearly they have views, but they're being asked to provide a certain defined kind of information. Whereas what feels much more Klamath-like, frankly, about this case is there, and even stronger against the application of the consultant corollary, frankly, is there, even though the United States was a fiduciary for the tribe, had structurally very aligned interest. The fact that the tribe was in contention with other players, so too here, the Congress members are actively in their role as representatives of their members when they are providing information to and in dialogue with the executive. And there are other members who are not privy to those conversations who have divergent, different interests, just like the other claimants for water.
So there's a lot going on. I'm sorry.
Yeah.
There's a lot going on in that question. I want to unpack various pieces of it. So Let me start with the first piece of that, which is Your Honor's description of the Ryan case. I actually think that while some of the questions in that questionnaire in Ryan were kind of humdrum factual questions, those were the questions that this court in Ryan thought weren't covered by the deliberative process privilege at all. What the court drew a distinction in Ryan was those kind of factual questions, and then other questions that were likely to give information about how the senators were actually developing their recommendations and why they were recommending particular kinds of candidates as opposed to other kinds of candidates. And as to that part of it, I think it's very clear that you would expect the senators to have strong personal interests, that different senators are likely to approach that different ways. Some of them might be aligned with the executive branch in that regard, and some of them might not be. And I think that's part of why when the Supreme Court described the Ryan case in that footnote in Klamath, the Supreme Court didn't think it was hard to see that case as one in which the senators would have strong interests. And I think the fact that in Ryan, you had a wide swath of senators who might be aligned with the administration and senators who might not be aligned with the administration would be a harder case than this one, where here, as Your Honors have pointed out, we have declarations that talk about how the consultations with the members of Congress and their staff were consultations with people that at least the administration thought was aligned with them. So that's just one box that I want to talk about. Now, another thing that Your Honor said that I want to really push back on is how Your Honor is conceiving of the interests of the legislators. And I think it might be tempting in a case like this to look at interests in a really broad view and say, boy, like the question here was about what statute Congress should pass. And that's part of what was going on here. But if you look at the actual deliberations that are at issue, that's not all that was going on here. So for example, some of the consultations that are at issue in this case are situations where OMB is talking to members of Congress about statements of administration policy. And so these are things that, these are statements that the president makes, that the administration issues, and they say, here's what we think about pending legislation, and it's designed to achieve various results in Congress. And so some of the consultations were the executive branch going to members of Congress and their staff saying, okay, here's one way we could draft this statement of administration policy. What do you think about this proposal versus what do you think if we release it at this point in the legislative process versus what do you think about if we release it at another point in the legislative process? And I think when you think about, the interests on that more microcosmic level, then it's hard to see this really as a situation where the interests of legislators are necessarily adverse to others. Indeed, whenever you have a legislative process, it's so multidimensional. There are so many different things that can happen in a legislative process that at a bare minimum, it's not necessarily adverse in the Klamath sense. I also want to talk about the fact that some of the consultations at issue here are also just about presidential decision making. And part of presidential decision making is about trying to understand what legislators are getting at. So for example, one of the categories of documents at issue in this case is there's draft legislative language. And some of the consultations are things like trying to figure out what a particular legislator is getting at. Like, what are you trying to do with this draft legislation? Are you trying to get to this policy outcome? Or are you trying to get to that policy outcome? And again, these kinds of consultations are not ones that you look at and you say, okay, these have to be things where the interests are necessarily adverse to competitors. So I think all of this is to say that maybe the individual legislators have interests in the sense that they have strong personal views, but that's not the kind of interest that's disqualifying.
I'm really struck by that. Like, what do you know what the norms are? Do members and people within the executive typically have these strategy sessions that are sort of maybe intermingled with more, here's where we stand and here's what we think about more kind of reporting on information that only the members could provide? Like, and has it been the assumption that this is all confidential under Exemption 5, or has it been the assumption that it's not? Or I'm just surprised that this is coming up now.
So I don't know that I have much to offer about sort of a broad, long-term understanding. I can tell you what's in the record in this case, and both the HHS declaration and the OMB declaration talk about the expectation from the people in those agencies that these would be confidential communications, and they thought that their counterparts in Congress that they were communicating with shared that expectation.
But these are relative newcomers. They may know nothing about how this is usually done.
Your Honor, the declarations don't say whether this was their first stint in government, whether they had been in government past. So I agree that it only tells you so much to answer Your Honor's question.
What's your view on the issue of the district court finding that there was a common interest, and what import that finding should have, and how we should review that finding, if at all, what standard we should use to review it?
Sure. I mean, I think if you talk about, if by common interest, you mean that they were not, they didn't have adverse interests in the Klamath sense. I think the basic standard would be the summary judgment standard. And so this court would review summary judgment de novo. Your Honor is right that to the extent that the evidence might have shown, theoretically, that the record might have shown that there is a disputed material issue of fact, that, of course, the various procedural rules for how a party is supposed to present that argument to the district court would certainly apply. And so if somebody's evidence showed a dispute of material fact, and then for whatever reason, they didn't adequately call that to the district court's attention, we would agree that that would change the standard of review. The court wouldn't just look at the underlying evidence, ignoring that procedural backdrop.
Counsel, can we go back to what I'm struggling? I'd just like to hear what you would say is the rule that we're applying. I think in your brief, at some points you suggested sort of the broad Ryan articulation, essentially anything that's deliberative. And at sometimes today and in your brief, you also used the facts of Klamath as whether the outside entity not only has a self-interest, but is somehow adverse to other competitors. Is it the latter that you're advancing?
So I think the test for whether the consultant corollary applies, I would articulate it as a two-step test. The basic test is the test that appears in this court's case law, which is the court looks at whether the documents are part of the agency's deliberative process. The second part of the test is we know from Klamath that there is at least one exception to that rule, the Klamath exception, which is if you have the putative consultant as an entity who has their own self-interest and they're necessarily adverse to competitors being over a limited pool of resources that are necessarily inadequate to satisfy everyone, we know that the consultant corollary cannot apply in that situation. So I think
if we use that as the test, right? One thing Klamath says very clearly is that we need to give some intelligible meaning to the words intra-agency. So it can't just be step one.
Correct.
And so on step two, how would you explain how that test relates to whether something should be deemed intra-agency? And I'll just say, whether they act like an employee in the sense that they don't have an interest in the outcome seems a very straightforward way to think of someone as intra-agency or not. You're acting as if you're an HHS employee or personnel.
Sure. Well, I
don't understand the connection of this adverse interest test.
Sure. Let me start by kind of exploring just how I think the interest is a bit of a red herring here. And so if you just think about what it means for a document to be intra-agency, like to use the example of the Department of Justice, there are plenty of deliberations within the Department of Justice, say what position to take in litigation, where there are parts of the Department of Justice that have very different interests. Some parts of the Department of Justice are charged with affirmatively enforcing certain kinds of statutes, and they take a very pro-enforcement view. Other parts of the Department of Justice are more defensively minded, and they take a very defensive-minded view. And so in the process of determining what the department's litigating position would be, you might find very strong, very divergent views from components that have very different interests. But nonetheless, the underlying interest here is one of acting, in support of the American people, of furthering the government's mission. And I think
that's just explain why the test can't be whether the people communicating have adverse interests.
Sure. I think if you think about what it means to be intra-agency, my point is there can be parts of an agency where different parts of an agency have very strong and very divergent interests, but we've never thought of interest in that narrow sense. We've thought, I think when Congress used the term intra-agency, it could not have been thinking of interest in that narrow sense. And then same thing with interagency. You have situations where you could even have one agency suing another agency in litigation. As this court well knows, as it sees some of those cases. But again, I don't think I hear the other side saying that those aren't, that those aren't interagency documents. And so that's why I think just looking at this interest is such a red herring.
But I thought that Judge Garcia was saying that the bigger umbrella or the more significant test is whether the putative consultant is acting in a role akin to that of an employee of the agency, and that the interest is part of exploring that. And so I guess if we were to accept your view, I'm not sure what would distinguish, an industry sector that was interested in a particular piece of legislation, and OMB and HHS are thinking, let's say it's pharmaceuticals. Well, it's going to make a big difference to various key legislators whether this sector supports this legislation, and we've seen their template legislation. What do they mean by A, B, or C? Maybe we could tweak that. And if that relationship renders that sector to be a consultant, I think we've very substantially broadened the applicability of the interagency deliberative process exemption.
So I don't think the court needs to go there to decide this case, and there are a couple of ways that it can avoid that outcome. One is that we've explained that, at least when you're talking about interbranch communications, whether it's with Congress or with the judicial branch, those are in a unique category because the oath of office that
I don't know. I
Well,
mean, I'm just saying that it feels like the different branch under the Constitution has a live, dynamic, and irrefutable interest in acting in, not as the agent
I mean,
of another branch.
so respectfully, Your Honor, if that were the logic, it's hard to see how Ryan could have come out the way that it did. I think there are plenty of situations, and Ryan is one of them, in which when you have these interbranch consultations, government, the executive branch is asking a question, another branch has particular expertise, and they're sharing that expertise, just as happened in Ryan. And sure, it may be the case that that branch also has its own interest, but in Ryan, it certainly wasn't disqualifying that you also had your own interests. And indeed, Public Citizen is, if anything goes even farther, because those were private entities. Those were former presidents who were not currently in government. And they clearly had their own strong interests. And nonetheless, this court in Public Citizen concluded that they were still operating in that consultant.
Well,
capacity.
this was-
Can I-
yeah, go ahead.
Could I just go back to the internal DOJ deliberations? Because it does actually hopefully maybe clarify where the question is coming from. What Klamath says is that you can have a point of view. Of course, you can have different points of view. What you can't have is different interests in the outcome. Another way of saying that would be you can have a view, but you can't have a stake. If one of those employees in the DOJ, in the civil division, is related to one of the parties, they can't be in that room. And in that sense, they are not like an employee. The analogy here would be that Congress, especially in a case like this, where there's a negotiation and a give and take, even if they were perfectly aligned in terms of the interest, Congress has an independent stake because they're always representing their constituents.
So I want to push back on that on two different dimensions. First of all, I actually think your example is a great one, because if somebody, for example, violated the ethics rules within DOJ and worked on a case where they had a personal interest, there might be consequences for them as an attorney, but I don't think it would deprive the communication of its intra-agency character. In the same way, if, for example, an attorney sought ethics advice from someone within DOJ and they said, hey, I may have a personal interest in this case, but it might also be a waivable personal interest, and they consulted with ethics people about whether or not they could waive that interest, the fact that they might have had a personal interest, again, it wouldn't disqualify it from being an intra-agency communication.
My point, obviously anything that happens within an agency is intra-agency. I think my point is that if the test were, are you functioning like an employee? The way you know whether you're like an employee or not is whether you only have the interest in giving good advice, or if you somehow have a stake in the outcome.
So I want to push back on that part of it as well. Part of why I don't think that's quite the right articulation of the test is because we know from Klamath that whatever the court in Klamath thought was the typical situation where you had a consultant corollary, and maybe what Your Honor is describing is the typical situation. Klamath also acknowledged that you have the Ryan type situation and you have the Public Citizen situation.
But I took that to be a much more raising a question mark about their continued vitality, because what the Supreme Court said was these two cases arguably extend beyond what we have characterized as the typical examples of the consultant relationship. And I guess you're reading that as they extend beyond, and therefore the typical model isn't the consultant corollary is not limited to the typical. But another way of reading it is we're the Supreme Court. We're not sure that what the DC Circuit has done is within the confines of the rule we're laying out here today. So DC Circuit heed that going forward. And to the extent that that's the reading of that footnote, then I don't think we can lean too hard on Ryan and Public Citizen.
Well, respectfully, Your Honor, I think this argument might look a little bit different if it were an argument in the Supreme Court. But here we have all of this court's existing precedent. We have Ryan, we have Public Citizen. They are the binding precedent of this court. We know that Klamath did not overrule them. We know that this court has, since Klamath, acknowledged that Klamath did not overrule them. And so I think for our purposes, Ryan is good law, Public Citizen is good law, and it's not the correct reading of the consultant corollary to say that you have to have no interest.
Thank you.
The test the government suggests, the necessarily adverse test, is not inconsistent with Klamath, but is not required by it or this court's precedent either. And indeed, I'm not aware of any court of appeals that has reduced Klamath to its most narrow fact-bound holding. Our formulation is wholly consistent with this court's discussion of its past precedent in Peer, and is also consistent with Ryan and Public Citizen. As to Public Citizen, that case itself stated there may be some point where features of other relationships might eclipse the consultative relationship, and that was when Public Citizen said, we're not there yet. This is at 111 F3rd at 171. I would submit that we are now beyond those facts of Ryan and Public Citizen, and that the government is seeking to broaden this atextual consultant corollary against a backdrop of cases where the Supreme Court recently and Milner and Argus Leader have rejected atextual glosses on exemptions 2 and exemption 4. The court makes the point that agencies can have diverse interests, and that certainly is true. They can have views within the agency, but that's part of the deliberative process and doesn't raise the textual concern that our case does, because those are still purely intra-agency on the face of the text. My colleague is correct that legislation is multidimensional. And because it is multidimensional, there are multiple factors of stakes that members of Congress have whenever they are negotiating what should go into a bill, whether to vote for a bill, and whether they hope the president will endorse it or sign it or not. And because of those divergent interests, the consultant corollary is inappropriate in this case. Unless the court has further questions, we ask the court to reverse.
Thank you.
Thank you, Your Honor.
Admitted. Thank you both for very able arguments.
Case number 12-1151 et al., Columbia Gas Gulf Transmission LLC petitioner versus the Federal Energy Regulatory Commission. Mr. Flume arguing for petitioner Range Resources Appalachia. Mr. Higgins arguing for petitioner Columbia Gulf Transmission. Mr. Ediger for respondent, and Mr. Etchemendy for intervener.
Good morning, Mr. Flume. You may
Morning, Your Honor.
proceed whenever you're ready.
Thank you. Good morning, and may it please the court. My name is John Paul Flume. I'm appearing today on behalf of Range Resources Appalachia LLC. Range is a long-term firm shipper on the Texas Eastern and Columbia Gulf systems. They hold a 15-year contract that continues through 2032 for 200,000 decatherms a day of capacity on both pipeline systems. Range has no physical capability to monitor or manage the pressure differential between Texas Eastern and Columbia Gulf systems. And without action from this court reversing the FERC's decisions on the issues before the FERC and in the orders under review here, Range will have no ability to guarantee that the gas that it delivers for shipment on Texas Eastern will ever make it to the Gulf system. This court owes FERC no deference in its interpretation of Section 6.2 of Texas Eastern's tariff. That tariff provision specifically says that Texas Eastern is required to deliver gas at pressures as are available at the point of delivery and resulting from Texas Eastern maintaining a discharge pressure of 750 PSIG at the nearest upstream compressor station.
And that would have been Danville.
That would be the Danville station, yes, Your Honor. Yes.
But I did not see in your complaint where you alleged that 750 pound pressure had not been maintained at Danville.
Well, Your Honor, I respectfully, there's 2 points that I'd like to make about that. We did allege that in our complaint at paragraph 24 of the Range complaint, where we discussed the applicability of the tariff provisions and Texas Eastern's violation of those, as well as our violation of our service agreement with Texas Eastern. But also, Your Honor, the court doesn't even need to get to that point necessarily. We need an undoing of this errant interpretation of the tariff itself. If we accept As a matter of fact, the FERC counsel in their brief, where they have stated that we can resubmit our complaint properly alleging those claims, as Your Honor has pointed out, perhaps we should have put it differently. We still have the legal error of FERC's interpretation of Section 6.2.
I don't see in paragraph 24 where you alleged that there was less than 750 PSIG. Rather, it just quotes section 6.2 saying that the tariff requires Texas Eastern to deliver gas at pressures that are available at the point of delivery and resulting from pipeline maintaining a discharge pressure of 750 pounds per square inch gauge pressure at the nearest upstream compressor station, which is what the tariff says.
Certainly, Your Honor. There are 2 points on that again. The FERC then, taking what we have put in our complaint, the FERC then interpreted Section 6.2 to completely read out the resulting from the maintenance of a discharge pressure.
They did, it's true. They did not quote that. But I guess my question is the inference, you're saying it was a necessary implication of what you've pleaded that the pressure was lower at Danville than it should have been because in the end, the pressure down at the interchange was lower. But is it entirely fair to assume the gas that's flowing 37 miles down pipeline would lose a lot of pressure between the Danville station and the interconnect?
That's a great question, Your Honor, and we would have loved it if FERC had actually asked the question and given us the opportunity.
But it's your burden. It's your burden.
Certainly.
So without the allegation that the pressure at Danville was below what it needed to be and that was the cause, it doesn't seem like you've alleged any violation of Section 6.2.
Well, Your Honor, I would suggest that also in the reference to paragraph 37 in that same paragraph 24 of the range complaint points out that there were some pressures that we had available from the Columbia Gulf system in the 2019 curtailment. And those pressures were well below the 750 PSIG limit that was at the Danville or that Texas Eastern was required to maintain under its tariff. So we did allege that there was a mismatch between the 750 PSIG discharge pressure that should have been operating at the Danville station and that the pressures that were apparent on the Columbia Gulf side of the system.
Counsel, I think in paragraph 37 of the joint complaint, the essential argument is that Texas Eastern had capacity. Its MAOP was higher than the average delivery pressure that it would have needed. But it does not say that we know there was a breach of Section 6.2 because if there was a 750 PSIG maintained at Danville, it would have been above X at Adair. Isn't that the kind of allegation and explanation you would have had to make this claim?
Respectfully, Your Honor, we certainly believe we pled the complaint properly and the allegations properly. In hindsight, had we pled it differently, that we probably would not be here before you today, hopefully. But the problem that we have with the FERC decision is just take as a fact or just take as an assumption here that we did not plead it properly. And FERC could have said that in its initial order dismissing the complaint that you didn't address the issues that are in the tariff. We'll leave those for another day. As FERC counsel has mentioned in the FERC brief, we have the right to replead these claims. The issue that we have is that FERC has improperly interpreted the tariff to read out the obligation. So even if we were to raise this claim in a future complaint.
Well, they omitted it, but I don't think they're depending on reading it out. They're just not crediting the implication that you would like them to credit.
I would suggest, Your Honor, that unfortunately the FERC in two instances in both the order on rehearing and the dismissal orders stated that the tariff imposes no obligation on Texas Eastern with regard to minimum pressures.
With regard to minimum pressures at the Adair interconnect.
If they had said, I'm sorry, Your Honor.
You're saying that you read that as saying that there's no requirement of pressure at Danville. I think what they're not even reading you to have alleged that. So their statement to that effect doesn't negate that. What they don't think you've alleged, they're not negating.
And if that is how the court is viewing the FERC's determinations, and if that is how FERC counsel is willing to state that the agency is reviewing this, I don't think we have an issue at this point, Your Honor. We can re-raise the claims before FERC. Our concern is that We re-raised these claims at FERC. FERC says, no, we addressed that and said there's no tariff obligation. So right now we have what could be construed as a very broad reading of responsibilities or lack of responsibility under the tariff that we are now precluded from raising in a subsequent complaint under 6.
But how could the construction of the tariff applies to, to all shippers, right? The 750-pound requirement is in your, I guess, firm agreement with Texas Eastern, right?
So actually, Your Honor,
How can the construction of the tariff undermine what they're required to do in the firm agreement? Am I missing something?
well, under FERC policy and precedent, Your Honor, the service agreement, actually the service agreement itself incorporates the tariff by reference. And under FERC policy and precedent, the service agreement cannot control over the generally applicable tariff provisions unless there's a specific provision that removes that right. The way that the service agreement itself is structured is it says that it's at the available pressure, but the base level default rule for all shippers on the system, as Your Honor points out, would be the tariff. The service agreement does not modify that obligation that Texas Eastern has to maintain that 750 PSIG.
I see. So if we said that we don't read FERC's opinion as essentially undermining the service agreement requirement that there be 750 pounds of pressure at the nearest compressor station, that would alleviate the concern that you are articulating?
With respect to section 6.2, yes.
With
Your Honor,
respect to
yes, that is
6.2.
correct. Yes. We still believe we pled this properly and that should have been taken to the FERC, obviously.
Good.
And is there anything in the record about how quickly natural gas loses pressure on a pipeline as it travels away from a compressor station?
That would have been a question that we could have asked, Your Honor, in discovery, which is why we wanted an evidentiary hearing. Range expected to receive an evidentiary hearing. Texas Eastern is the only party in the proceedings before the FERC that has the information that we would have needed to prove up the claims about whether they were in violation of the tariff or not. Absent a hearing, we can't do that. FERC does not offer discovery rights to parties when they file a complaint. You have to have the process set for an evidentiary hearing before the rules at FERC apply for discovery. So we had no opportunity to really bolster the analysis. I'm sorry, did you have a question?
No, please.
To bolster our analysis of whether Texas Eastern was in violation of the tariff absent the hearing. FERC's complaint rules do contemplate that we would have a hearing with the ability to have discovery rights to prove up that.
On your claim that you were similarly situated but not treated as well as other shippers, are the Liberty meter and the Kentucky Energy meter, do they have interconnects or not?
They are meters with, I believe, local distribution companies, Your Honor. So they would be like just essentially a meter off of the pipeline. They're not interconnecting with an interstate pipeline.
There's no, but there is an interconnect to a distribution.
I don't actually know that, Your Honor.
The reason I'm wondering is just whether it's, if they don't interconnect, then that might be an explanation why they wouldn't experience the same reduced flows as at a DARE.
Well, certainly. So an interconnection, Your Honor, in the sort of industry sense of it would be a connection between an interstate pipeline
and interstate.
Right. So in the context of, I think as you're describing it, and don't mean to put words in your mouth, but they do interconnect with a facility. I believe that they are local distribution systems. It would simply be a meter measuring the amount of gas flow going from the Texas Eastern system to that system. And that does point out the problem that we have here with respect to the similarly situated shipper context. Those two meters are on the same mainline path as the Adair interconnect. The fact that they received 80% of their nominated quantities during one of these curtailments and Range received 0 is a clear indication that Range was treated differently, treated in a situation that could result in undue discrimination against Range. The fact that we were not presented with the opportunity to prove up our claims about being similarly situated is really an error at FERC in the application of its own rules and its own precedent. FERC has declared that similarly situated context and that review is a uniquely and intensely fact-specific review. So that is something that we expected FERC to take into consideration. I would also...
Can I ask a question about the reservation credit issue?
Sure.
As I understand it, I know this is simplifying. You're essentially saying you would be entitled to 10 more days of reservation credits if force majeure was not properly declared, right?
For one of the outages, yes.
For the 2021. And what FERC said, at least in part, was that that was irrelevant because Range had actually already withheld payment for those reservation credits. And what they say in the initial order and on rehearing is that for some reason means you're not entitled to relief in this proceeding. I didn't see a response to that holding in your briefs. Do you have an argument
Certainly,
about why
yes.
that's incorrect?
It's incorrect because, yes, we withheld payment, but we would have to make the payment. If the FERC determines that there was an appropriate declaration of a force majeure and we were not entitled to the full amount of reservation charge credits, then we would have to pay those to Texas Eastern. There's an
So
injury
you were
there to
basically
us.
seeking a declaration.
Essentially, yes.
Yeah, I don't really follow that, and I guess we have to ask FERC, what's at issue is the net that's owed between the parties, and if it's not force majeure, then you would be entitled to withhold more of what you're withholding. If it is force majeure, so you would have to pay for the first 10 days.
So in the reservation charge crediting context, Your Honor, if there is a force majeure outage, there's a 10-day safe harbor in which the pipeline is entitled to recoup the entirety of reservation charges from the shipper.
Right.
After that, there's a full payment or reservation of the reservation charge credits. We'll call them demand charge credits so we can avoid reservation on both sides of that statement. So the demand charge credits themselves are paid, there's a credit back to the shipper of the amounts that would have otherwise been owed. In a non-force majeure context, there is no 10-day
Right.
safe harbor. There's simply
Right.
just, they take effect immediately. So the question becomes, what is owed to Texas Eastern from Range?
Right.
And Range did withhold, assuming that they had full reservation charge crediting capabilities and were entitled to that difference. As we get to FERC, and if we have a final order from FERC about this, that we do owe that is the damage to Range. And that's why we needed to have an understanding of the applicability of the force majeure declaration.
But isn't the order written as if you're never going to have to pay that? I mean, that's the way I read it. Maybe I just wasn't paying close enough attention. The funds that you withheld. Written as if there's no harm because you withheld those funds and you're never going to pay them.
So Your Honor, respectfully, I don't know how FERC could think that. Its rules state that the reservation charges are owed to the pipeline. That's what the tariff requires, and that's what the service agreement requires. I can't see and envision a situation where FERC would have assumed that we get to keep those no matter what. So it does present a bit of I don't know what FERC was thinking. Perhaps the FERC counsel can address that for you, but that certainly is a puzzling question for us as well.
I have a question about the interaction between the pipeline pressure claim and the force majeure argument. If this is not the way they discussed it, but if FERC is correct that that sort of it's on your client's head for not having written minimum pressure at the interconnect into its contract, and therefore Texas Eastern has no obligation to maintain a minimum pressure at the Adair interconnect, then why is force majeure even relevant? Because when something happens on Texas Eastern's pipeline, there's no minimum pressure obligation to be violated there.
That's a great question, Your Honor. That's another point that we did raise in our complaint with respect to the application of section 17.1 of the tariff. It's not something that we briefed before this court, so I can certainly address that if you'd like. But the point being, and this is an issue that Range has struggled with, Range, as I mentioned at the beginning of this argument for you, has no ability to physically change how the gas is flowing on the system or increase or decrease pressures.
It does have ability to write a contract up front, and I read FERC's orders to say that's where the problem arose.
And I agree with you that is what FERC's orders say. I question, though, for you, and I ask your honors to question as well, how is a shipper that has no optics into what the pressures are between two interstate pipeline systems supposed to know what the minimum pressure would be? And that's for us, at least as the shipper on the system, we don't know. what the pressure is, other than what the tariff states is the 750 minimum that's going to be discharging from the upstream station, and the 575 is the suction pressure on the nearest downstream station. We don't have any understanding if Range had negotiated a 600 PSIG minimum at that point. Is that enough? Is it not enough? And so the question really that I think from a broad policy perspective for FERC that FERC never really took into account here is how is it that the shipper, the one entity that never has the ability to change the pressure, supposed to negotiate about pressure? And that doesn't have any of the information related to the pressure other than MAOP. That's public information. Everything else is private.
We can ask FERC, but my understanding from having read their orders would be that is precisely why it would be incumbent on a shipper to write in a minimum pressure obligation, precisely because you don't have any ability once you're relying on them to ship.
And that's a fair point, Your Honor. But I would suggest that how does the shipper know what the pressure should be? I agree that perhaps a shipper should, from a contractual perspective, make sure that they are covered under their contract as best as they can. They do have a tariff that says that, the pressure obligation.
Back on the force majeure issue for a moment. So there are these 10 days that either free pass for Texas Eastern or not. Can we tell from the record which days those are?
I don't have the joint appendix sites in front of me, Your Honor, but I believe that they were the period between, I think it was late May, early June of 2021 through the end of July was the 2021 outage. So I believe it would be that first part of June of 2021. That would be the dates applicable.
I thought it
apologize.
was, so if it's maybe May 28th to June 8th or something like
Something in
that.
that timeframe, yes, sir.
And then the period following that is a little unclear to me why it's 0 for 23 days.
There were the nominated quantity that, so the force majeure doesn't necessarily only last for 10 days.
Right.
The outage that occurred there, at least for some of the lines that are at issue that connect with the Adair interconnect, the PHMSA had required that, or I guess they refused to grant a waiver to Texas Eastern to continue operating at its existing MAOP. With one of those lines in particular, there was no obligation to reduce the pressure. So that is also part of our consideration and concern here is what was the requirement for the declaration of force majeure. But the point being, Your Honor, sorry, is that the pressure differential between the two pipeline systems at Adair continued for a period of way more than 10 days. That maybe was related or not.
So with respect to Northern Natural,
Yes, Your Honor.
My reading of the case is that, well, one difference is that between, I guess, I'm not sure the right terms, kind of the downstream pipeline and the upstream pipeline, there was a minimum pressure agreement in the agreement between those two entities, which we don't have here, or at least explicitly. But the bottom line is the court said just looking at, or FERC said just looking at the tariff of the receiving pipeline, there was no obligation with respect to adjusting pressures in order to be able to receive the gas from the other pipeline on the other side of the interconnect, so to speak. And that was really all they needed to do to decide that case. And FERC says, anything else we said there is dictum. So what's wrong with that way of looking at Northern Natural?
And Your Honor, my colleague was going to address the Northern Natural.
Oh, I'm sorry.
But I actually, just to clarify.
And I can wait.
Okay, I can clarify if you wouldn't mind, Your Honor, and two, the points though that just for your benefit, there was not an existing firm service agreement between Northern Natural and ANR at the time of the FERC order that had expired prior to that point. Number one, and number two, just for clarification, in
The one that that before it expired, it had the.
It had a minimum pressure obligation.
Pressure obligation.
That's correct, yes. And just to be clear, to align the parties correctly in the way of thinking about this, ANR and Columbia Gulf are both the downstream pipeline. Northern Natural and Texas Eastern are both the upstream pipeline.
Yes, yes.
So just to circle back on something that I think you answered, if there were no minimum pressure obligation at the Adair Interconnect for the reasons relating to the interpretation of the tariff agreements, then that would undercut the importance of the force majeure or not finding, because Range would not be owed any credits. Is that right? It
In
wouldn't
the
matter.
context of these two curtailments, yes, Your Honor, that's correct. We will be owed nothing.
Thank you.
All right, thank you very much.
And I think you've reserved a couple minutes for.
We did, I
rebuttal.
did 2 minutes, Your Honor, yes.
We'll give you time, even though we took you over.
Thank you very much, appreciate it.
I believe we're next hearing from Mr. Higgins.
Thank you, Your Honor. Good morning. Matthew Higgins for petitioner Columbia Gulf. I have 3 points to make this morning. First, why Columbia Gulf has Article 3 standing. Second, why FERC departed from its past precedent without reasonable explanation. And third, why the interconnection agreement and FERC's misinterpretation of that agreement merits remand. And I'd like to quickly start with standing, though I'm also happy to get right into Judge Wilkins' questions if he prefers. But if I may, Columbia Gulf standing is very clear from Trillo's affidavit. First, it makes very clear that from the 2019-2021 curtailments, Columbia Gulf suffered significant administrative and operational harm. And that's a point that FERC's briefs don't really get into. But administratively, FERC was required before the curtailments to issue the notices at JA 177, 185, and that comes directly from FERC's regulations. And we submit that as enough to constitute a concrete injury under Article 3.
I think you said FERC was required to issue the notices, but you mean.
Oh, no, I meant Columbia
Gulf.
Gulf. Excuse me. I misspoke, Your Honor. Yes. Yeah, and that's under 18 CFR 284.13D. Columbia Gulf is required to issue those notices before curtailing ranges.
That kind of injury is only regressible if it happens again, right? You want us to make it not.
Correct. So, yes. So we have a concrete injury that comes from these curtailments. And then we have a substantial risk that these curtailments will happen in the future based on what Trillo said in his affidavit, that the conditions that existed in 2019 and 2021, the pressure differentials that existed that gave rise to these curtailments, the conditions are even worse now after the Louisiana Express Pipeline went into service. And based on those conditions, Columbia Gulf has taken steps to mitigate the risk of that substantial risk of harm coming in the future from those curtailments. It is taking Texas Eastern's gas, which is lower pressure, and looping it around its own pipeline, its own system, to a compressor station 12 miles away, compressing that gas, sending it back down, and then which allows the gas to actually enter into Columbia Gulf's system. Without that workaround, it would not be able to receive Texas Eastern's gas. And because of that workaround, Columbia Gulf is using its compressor without any compensation. There's additional maintenance costs. There's additional operational costs to that, which Columbia Gulf otherwise would be allocating, reserving for its paying customers. Instead, it is using to compress Texas Eastern gas.
FERC says that that's a voluntary kind of obligation you're taking on, and that's not sufficient to confer standing.
Correct. I think what FERC's argument is kind of in two parts. One, I think they're saying it's voluntary or self-imposed because they don't believe that Columbia Gas is harmed from the curtailments. They don't believe that Columbia Gas suffers the concrete harm when it curtails range of service. But of course it does. It suffers the administrative harm that I referenced, the JA 177 to 185. There's massive operation. When Range's lower pressure gas does not come into Columbia Gulf's system, there's a void, and Columbia Gulf needs to scramble daily to fill that void. And this is laid out in Trillo's affidavit. It needs to use third-party storage from gas. It needs to get excess gas from other pipelines in order to have enough gas in its system so that the pressure is high enough so that its system actually works. It also needs to stay in constant communication with range throughout these curtailments, which is another type of operational harm. So I think
This reminds me of something that was a little bit mysterious to me in the record, which is why the flow levels between June 9th of 2021 and July 1st of 2021 were 0, when I thought that there was some pressure on Texas Eastern, and why was it not being, why did Columbia Gas go all the way down to 0?
Yeah, so the flow levels from range were 0 because that gas was lower pressure, but there was other gas on the pipeline that was higher pressure that was needed in order for the pipeline to function properly and actually.
Range had a reservation, and so I just don't understand why some of Range's gas wasn't going.
So none of Range's gas could be going at that point because the imbalance had grown so high. Once the imbalance had grown as high as it did, accepting Columbia Gulf wasn't able to accept any of Range's gas because that was lower pressure gas.
Accepted other shippers' gas on the same pipeline at the same place, or no? Else?
Not on the Texas Eastern pipeline, but kind of where the Texas Eastern pipeline at the interconnect around that area, other gas was flowing through. Gas needed to be at that point on the pipeline in order for the pipeline to actually function properly. It just could not have come through the Adair interconnect.
So there's another pipeline, another analogous to Texas Eastern that Columbia Gulf effectively turns to at that point.
That's my understanding, yes, Your Honor. The Columbia Gulf needs to get this additional gas that comes from excess gas from other pipelines and third-party storage, and that gas does not come through the Adair interconnect. It comes through other sources.
So it wouldn't have been possible at that time for Columbia Gulf to, let's say, isolate a lower pressure segment of its pipeline to receive more than the 0 decatherms during that period.
Correct. That's the abnormal mode that Trillo discusses in his affidavit. It isolates part of his pipeline, one of his 3 pipelines, which is supposed to be going south. It pushes Texas Eastern's gas north, compresses it there, and sends it back down. But that's only possible if the pressure differential is manageable. And during the dates that Your Honor Pillar is referring to, the pressure differential was simply not manageable.
So you said you were going to talk about the interconnect agreement.
Yeah, if I may answer Judge Wilkins' question first, starting with Northern Natural and specifically FERC's treatment of the Columbia Gulf tariff. So the tariff for the receiving pipeline in Northern Natural was ANR, and it has substantially identical language to Columbia Gulf's tariff. And what Northern Natural said is that tariff language applies because, to answer Your Honor's question, there was no agreement, in fact, between the delivering pipeline and the receiving pipeline. At paragraph 23, Northern Natural is very clear that agreement expired. So in its ruling at paragraph 23, which relates back to ANR's argument at paragraph 14, what FERC said was that it agreed that provision, the provision again in ANR's tariff, which is substantially identical to Columbia Gulf's tariff, that it requires Northern Natural, the shipper, to deliver gas to ANR at pressures sufficient to enter the pipeline. And then at 23, it said we also concur with ANR's interpretation of its tariff requirements. So in Northern Natural, FERC applied substantially identical language, which included the word shipper, to the delivering pipeline. And here it simply did not. And kind of more than that, it didn't even acknowledge that in Northern Natural, it applied this substantially identical tariff language to delivering pipeline. And that unexplained about face on this tariff interpretation is an independent basis for vacatur. If there are no further questions on Northern Natural's interpretation of the tariff and how that relates to Columbia Gulf's tariff, I would conclude by noting that FERC only really offers a paragraph responding to its differential treatment of this tariff language. And it is alone basis for remand so that FERC can acknowledge its past precedent and then either apply that past precedent, that interpretation of substantially identical tariff language, and apply that to Columbia Gulf, and knowingly abandon it, or offer some sort of explanation for why this substantially identical language applied in a previous case doesn't apply to this case. And then second, and apart from the tariff language, FERC alternatively ruled, and this again under substantially identical facts, separate from the tariff, that delivering pipelines would be responsible to modify its facilities to actually make deliveries. And the order on review, FERC's main rationale for not applying that rule was that in Northern Natural, the delivering pipeline was the plaintiff, and here the delivering pipeline, or here Columbia Gulf, the receiving pipeline was the plaintiff. But under Kentucky Municipal and this court's other precedents, past precedent counts as past precedent regardless of which party raises that argument.
But I guess what I'm not understanding in your Northern Natural argument is that in Northern Natural, paragraph 23, FERC does say that section 11.1 of NR's tariff specifies that gas be delivered at a pressure sufficient to allow gas to enter ANR's system. Yes, FERC acknowledges that that statement is there. Yes, that identical language is in Columbia Gas's tariff. But what FERC holds is that that doesn't mean that Columbia Gas has any, that in that situation, ANR has any kind of obligation with respect to changing its system or decreasing pressure or anything in order to receive the gas, which was in effect the relief that was being sought in Northern Natural. And so, they had no occasion to rule on what the kind of obligations were of I guess they were saying that this is Northern Natural was seeking a remedy vis-a-vis ANR, and FERC said you're not entitled to that remedy, essentially, right?
Correct. FERC says you're not entitled to that remedy because any obligation to perform a system modification would lie with the delivering pipeline, which in that case was Northern Natural. So what this court says counts as past precedent is not just the result that FERC comes to, which Your Honor Wilkins correctly knows is the result was nothing was ordered, but what we also looked at is the steps that FERC takes to reach that result. And the steps that FERC took to reach that result were saying the receiving pipeline has no obligation to modify its system in order to receive the delivering pipeline's lower pressure gas because those obligations rested with the delivering pipeline. And that is the rationale, I think very clearly, that FERC used. And that's the rationale that we would ask them to reasonably explain why it doesn't apply here. And they simply haven't.
I thought their understanding was that the language in 4.02E of the interconnection agreement just requires both parties be assured of having the physical capacity to deliver or receive gas through the interconnection to the maximum allowable operating pressure, just giving each pipeline the flexibility to operate up to their maximum allowable operating pressure, but that without a contract term requiring a minimum pressure that just doesn't support the claim that it violates that provision when they don't operate at a minimum pressure.
Right, so this is separate from our Northern Natural argument. Northern Natural
Yeah.
applies only when it's inconsistent with the contractual obligation. But no, absolutely. The 402E contract we think is very clear based on the word therefore between the first and second sentence. The first sentence is all about pressure. It's all about being able to operate at the pressures up to the MAOP. And the second sentence is all about having physical capacity to enable those types of pressures. I think what FERC is saying is there's a physical capacity requirement in sentence 2, and in sentence 1, there's a kind of pressure discretion. But the word therefore links those two sentences. I mean, if the physical capacity that Your Honor Pillard is referring to doesn't relate back to the pressure in sentence 1, there's no reason to link these two sentences together with the word therefore. We think it is a plain pressure requirement, is a plain requirement to be able to deliver pressure up to the levels of the receiving party's MAOP. And, obviously Texas Eastern has not done that in this case.
Can I go briefly back to Northern Natural?
Yes, please.
Because what the court focuses on is 11.1 says explicitly that Northern Natural, the shipper, is obligated to deliver at a pressure sufficient to allow the gas to enter transporter's existing pipeline system, and it rests on that.
Yes.
Are you telling us that there's the exact same language as in
Yeah,
Texas Eastern's tariff?
it's the exact same language. I'm happy to read it for your honors on page
Why are we
49 of our
talking about
opening
the
brief.
interconnection agreement in section 6.2? You haven't, that's in Texas Eastern's tariff.
It's in Columbia Gulf's tariff. I'm sorry, your honor. So the
Columbia Gulf's tariff.
the section 6.2 argument relates to the delivering pipeline Texas Eastern. Our Columbia Gulf tariff argument relates to Columbia Gulf's tariff. And again, it's also JA 43, 44, the joint complaint, paragraph 75 lists side by side A&R's tariff, the receiving pipeline in Northern Natural, and Columbia Gulf's tariff. Both say Columbia Gulf says shipper shall deliver gas or cause gas to be delivered to transporter at the receipt points at a pressure sufficient to allow gas to enter the system. A&R's tariff, which again is in the complaint, there's no procedural bar on this question at all. It's in the complaint, in the order, in the rehearing order, squarely presented to this court, says shipper shall cause the gas to be delivered at the receipt.
I'm sorry, tell me what page you're at so I can follow as you're reading.
Oh, sure, sorry. Opening brief 49.
Oh, I thought you were JA in the
Listen.
joint complaint. Oh.
List them both. And yeah, and this JA 909 is where A&R's tariff is. Columbia Gulf's tariff is at JA 43, 44. The opening brief lists them. Both apply to shippers. In Northern Natural, again, very squarely said that language imposes an obligation on the delivering pipeline to deliver gas at pressure sufficient to enter into the receiving pipeline system. FERC has not acknowledged that order. FERC simply says that Texas Eastern is not a shipper, therefore this provision does not apply, this provision from Columbia Gulf's tariff. But again, FERC has this past precedent and it has not acknowledged it. And by not acknowledging the past precedent, it commits kind of a textbook example of arbitrary and capricious reasoning.
I'm not sure that I follow that argument. The FERC says that Northern Natural was not a shipper. And so the tariff says shipper shall cause. So FERC says that means that it was really up to Range to cause the gas to be at a pressure sufficient to enter Columbia Gulf's system. And Range could have done that if they had written their service agreement differently, but they didn't. And so that's how they harmonize Northern Natural. Isn't that what they do?
I don't think so. They never acknowledged that in Northern Natural on their orders on review and the rehearing petition or rehearing order and even the briefs before this court, they never acknowledged paragraph 23, which squarely applies substantially identical tariff language, referring to a shipper, as Your Honor said, applying that language to a delivering pipeline. That's what FERC did.
But it's clear that shipper in Northern Natural was actually Northern Natural. Whereas here they're saying the shipper is Range and Range had I'm just repeating the premise of Judge Wilkins' question, but also that whole discussion wasn't really central to the holding in Northern Natural, was it?
Well, two things. Northern Natural did acknowledge that shipper in other contexts in the industry does refer to customers of pipelines. That's
Yes.
at paragraph 29. It's called Madison Gas Electric. It says the only existing or potential shipper to comment is a customer of the pipeline, but nevertheless, it applied that language, the substantially identical language, to a delivering pipeline. So in Northern Natural, FERC was aware of the tension.
But that wasn't really a holding.
No, I think it was, Your Honor. It was the first basis. I mean, paragraph 23 and 25 are the reasons for which FERC denies the delivering pipelines petition. It says
In Northern Natural.
in Northern Natural, it says the receiving pipeline does not have an obligation to lower its pressure because the receiving pipeline's tariff governs and the receiving pipeline imposes an obligation on the delivering pipeline to raise their pressure. And then at 23 and 25 says that if modifications are necessary, the record was incomplete. It says if modifications are necessary, those obligations rest with the delivering pipeline. And that comes directly from the tariff. There's a tariff-based reasoning for why those obligations rested with the delivering pipeline at paragraph 23. And there's a non-tariff-based reasoning at 25. And neither one of those has FERC given a reasonable explanation for why they would not apply squarely to this case.
You haven't addressed the basis that FERC relied on, which was that the 402E argument was forfeited, wasn't preserved.
Right. So what FERC, their main argument, I think, is that this court need not reach the merits of the 402E legal challenge because there was an alternative basis for dismissing the 402E claim. But that's not required for two reasons. First, I'd say FERC largely relies on the BDPCS case, but in BDCPS is very different from this case. Here, the merits decision was effectively a dismissal with prejudice, and the ruling about the sufficiency of the complaint was a dismissal without prejudice. Columbia Gulf and Range would have been free to file a new complaint that wouldn't essentially be futile if there weren't the merits.
Would not have been free?
Yeah, correct. Right now, essentially what FERC is asking Columbia Gulf and Range to do, as I understand their brief, they say we're free to file a new complaint with these claims raised. And respectfully, that's just, we don't think that's a path that BDCPS requires, given how different the facts are.
But it is available to you.
Our understanding is that it is available to us. I mean, the best case scenario, we believe this court shouldn't do that because it would be a big waste of judicial resources. I mean, we would file a complaint before FERC, knowing that they would deny the 402E claim, file a request for rehearing, knowing FERC would deny that, and then file another petition before this court, asking them to review the same 402E language that we're asking this court to review today. And I note too that the BDCPS case came on a very different, like the question came before the court in a very different way. Here, FERC reached out and decided the 402E claim without it being in the complaints, without Columbia Gulf or Range raising that issue, and then is saying that upheld that ruling and the rehearing request, and then is saying that this court is barred from hearing the merits. So the facts are very different from BDCPS. I'd say the facts are different enough that that holding does not apply here. And for the reasons I explained about the waste of judicial resources, there's no reason to not review the 402E claim, given the lack of controlling precedent and the waste of judicial resources that would come about from that. There are no further questions. Thank you.
And I gather you've also asked for a couple of minutes for rebuttal?
Yes.
Okay, we'll give you minutes. Morning, Mr. Ediger.
Morning. And may it please the court. I'm Scott Ediger for the Federal Energy Regulatory Commission. Thank you for hearing this case. I'd like to start with some of the procedural issues and the disconnect between scope of the complaints that were filed in this case and what's being asserted on appeal. The commission was very clear in its orders that we think the petitioners here have the issues backwards. So the commission was very clear that it need not consider arguments raised in the related to the upstream compressor station and related to the interconnection agreement. It said that very clearly in the rehearing order, paragraph 9 and note 34. And the commission pointed out in the following paragraph, rehearing order page, paragraph 10, JA 970, that the complaints govern the scope of the proceedings. So it's fair to confine the petitioner's view to the scope of their proceedings. And there's a fairness element to this because the commission's rules, 18 CFR 385-713, D do not permit and in fact prohibit answers to rehearing request. So it's not fair to the respondent, in this case, Texas Eastern, to be chasing a moving target. So there's good reason for the commission to dismiss arguments related to the upstream compressor station and the interconnection agreement. I do want to address paragraph 24 of the Range complaint. That seems to be the paragraph that Range feels is most compelling. And I would, the commission pointed out in paragraph 9 and note 39, JA 969 to 970, that the complaints never demonstrate that Texas Eastern failed to operate the upstream compressor station, which is the Danville compressor station, at 750 pounds. That's point number one. Point number two is the complainants never demonstrated that there's a connection between such failure to operate at 750 and what happened at the, I'm going to say border, at the interconnection between Texas Eastern and Columbia Gulf. We know that pressure will diminish as the pipeline goes on, and there's roughly 38 miles between Danville and the interconnection here. And so we would expect the pressure to decrease somewhat, and there's nothing in this record to provide that causality.
So it's your position that it is not a reasonable inference from the allegations of the complaint that Danville must have been operating below 750 pounds per square inch, given the concerns about the lower pressure at the Adair interconnect.
I think that's absolutely correct, Judge Pillard. And I would add a reference as well to 18 CFR 385-206B. This is the commission's regulations addressing what a complaint should do. And a complaint should do two things. It should clearly identify the action or inaction and explain how it violates the applicable statutory standards. And if I may say this, these are sophisticated parties in this case, and there's a lot about this case that's very confusing, but this would not be difficult to say in a complaint. We allege Texas Eastern is not operating upstream compressor station at 750 full stop. It's as simple as that. And then to ask, and our order 602 that the petitioner cite on reply, they quote a couple sentences. The commission goes on in that order and explains that, yes, and they're right. There's often information that's only within the control of the respondent, but in that case, you should provide what you can, and then you should ask for the information that you want, and the commission will decide such things on a case-by-case basis. And so and that wasn't done here. And I would suggest to your honors that just further drives home the point that this was not the claim that was advanced in these complaints, and the commission was absolutely correct to reject it.
Didn't the commission just leave out, when it quoted the section 6.2, the requirement that delivery pressures had to result from maintaining a discharge pressure of 750 PSIG at the nearest upstream compressor station? I mean, that raises a little bit of a question mark in whether the commission is dealing with that allegation, which was plainly alleged and was in the agreement.
But the commission quoted the tariff, certainly, and paragraph 38 of the initial order. But the parties never, the complainants here never alleged, that was the basis for the complaints. The assertions from the get-go were that Texas Eastern had an obligation at the interconnection to deliver gas that actually complied with whatever pressure Columbia Gulf was operating at. And they derived that rule really from their misinterpretation that we may get to about Northern Natural. That's really their theory, and that's really what Range is after here. This business about the upstream compressor station was never part of the original complaints. And if I may also add one more bit to that, in its answer, Texas Eastern pointed out that there lacks a clear explanation. They said this at Texas Eastern answer to the range complaint at page 3. This is at JA 613. And then, as you know, the commission in its rehearing order pointed out that in subsequent filings, there were many subsequent filings after that, that there's no mention of section 6.2 whatsoever. So the commission said that in rehearing order paragraph 9, which is at JA 969 to 970. So it just drives home the point that Texas Eastern said you didn't make it clear, and they didn't follow up and make it clear.
So the one argument
Go ahead.
one argument they clearly did preserve is, as you said, Northern Natural. And it seems today, at least, they're focused more on the fact that there is similar language here in Columbia Gov's tariff, not the proposition that it created some sort of generally applicable default rule. So could you just explain your response to their argument about paragraph 23 of the decision and the fact that Columbia Gulf has the same tariff obligation, please?
So I'm gonna say this, the commission, ironically, I think Northern Natural is actually a good case for what the commission did here. The commission followed the Northern Natural pattern. And the commission said this in its initial order at paragraph 62. This is at JA 869. What Northern Natural did was it analyzed the certificate obligations, the tariff, and the contracts in that case, and they found that ANR had no obligation to Northern Natural. And that's in Northern Natural paragraph 20.
Paragraph who?
I'm sorry,
You said
Paragraph 1.
paragraph 20 of the Northern Natural order, where the commission says we're going to consider the merits of the claim by Northern Natural, and we conclude that there hasn't been a violation of the tariff, the contract, ANR's tariff, ANR's contractual obligations, and certificated service obligations.
It said that there was no violation by ANR.
Right.
It wasn't at issue whether Northern Natural was in violation, right?
That's right. Northern Natural's obligations weren't before the commission, and that begs the question, I think it's unclear on what did Northern Natural have a contractual obligation to its shippers to deliver at some pressure. I don't think that issue was before the commission in that case.
Let me ask you this. Does Columbia Gulf's tariff include a definition of the term shipper?
I'm sure it does, and I don't think the precedent here could possibly be read to read in and to make Texas Eastern a shipper on Columbia Gulf's system.
So why did the commission refer to Northern Natural as having an obligation under the ANR tariff if the ANR tariff language at issue spoke of an obligation of shippers?
That case is complicated because there had been a contractual relationship between Northern Natural and ANR, but that had expired. And what the commission is saying here is that, and they say this in paragraph 64 of the initial order, that Northern Natural was not a shipper under the rehearing order paragraph 13, this is JA 972, that Northern Natural was not a shipper under ANR's tariff. And I will point out that the commission is entitled to deference in interpretation of its precedents.
I mean, I see that it made that statement, but did it explain why they called them a shipper in Northern Natural? They didn't.
It may have been because of Northern Natural had been there had been a contractual relationship previous. But
I mean, I guess that's the point, like under kind of the theory of Chinnery, et cetera. We don't try to discern what the commission was thinking from the briefs or your able presentation in court. We need to have the commission say what it meant and give adequate reasoning. And how is that adequate reasoning of why it was distinguishing its precedent?
I think the key again is part of the Northern Natural order is the paragraph I was just referring to. It's paragraph 20, which I would say was the central holding of the Northern Natural order, and that's exactly how the commission characterized it in the initial order in this case in paragraph 62, just JA 869, this is what the commission did in Northern Natural. It analyzes ANR certificate obligations, its contractual obligations, and its tariff, and it found that it had no obligation.
But I guess you say that it would have been very easy for them to plead, at the nearest upstream compressor, they didn't maintain 750 pounds pressure. It would also have been very easy for the commission to say, well, when we said in Northern Natural that Northern Natural had an obligation to provide pressure at sufficient to enter into ANR's system, what we meant by that was X. And that's not true here for this reason, or, we think that statement was dictum and here's why, or, we've rethought that precedent and we're not following it anymore. They could have done any of those things, but they did none of them.
Well, I think they did, Your Honor, and in the rehearing order in paragraph 13, they did point out that Northern Natural's obligations weren't before the commission, and that language was dicta. And the commission said, in any event, there is no such rule. I would point out as well that I don't think Northern Natural really applied such a rule. I think the better reading of Northern Natural and the reading that the commission took was that the commission in Northern Natural resolved the case by looking at its obligations. And we'd submit that that's exactly what the commission did in the case before you today.
Well, here's what I don't get. If it is, as you say, the proper reading of Columbia Gulf's tariff to say that the shipper shall cause, that shipper doesn't apply to Texas Eastern. It applies to Texas Eastern's customers, so to speak, that they shall cause the gas to be delivered at sufficient pressure, that's the proper way to read the Columbia Gulf's tariff. How is that administrable when really it is the delivering pipelines like the Texas Easterns of the world that really keep up with the proceedings when Columbia Gulf, expands its system and gets a new certificate, et cetera. I mean, I understand that shippers can and do comment and participate in those proceedings. But isn't the party that would make more sense to play the central role in those proceedings, the other pipelines that are delivering gas to the interconnects?
A couple points on that. Judge Wilkins. I think Range was a participant in Columbia Gulf's certificate proceeding here, the one that added the compression. So they were a participant. And I think the commission was spot on in paragraph 17 of the rehearing order, JA 975, when it said Range had an opportunity to protect itself here. And I think the way you do this is you have interconnecting pipelines and you can link them up. And we see that from Exhibit B to the service agreement, which is a JA 814, which has a space. That's one of the more important pieces in this record, which has a space which indicates where the delivery pressure should be. And in all caps, conspicuous language, it says that Texas Eastern shall deliver at the pressure available. That was the space that Range could have negotiated for something with Texas Eastern and could have linked up its pipeline such that you would have a smooth transition. And
So just from the commission's perspective, what do you envision that these parties who have this ongoing contract moving forward for many years would do?
I would
Go back
refer,
and file with more factual support and allegations, or do something, renegotiate contracts, or?
I would hope the latter, Your Honor. And I would refer Your Honor to trying to find in my notes the affidavit put on the record by Texas Eastern the affidavit by Huffman put in by Texas Eastern, and this is in particular paragraph 6, where Huffman points out that Texas Eastern has agreed to make agreements for a delivery pressure. And they have done that in the past. That I would submit is a pretty good step forward here. That's something the parties could negotiate and could make the appropriate arrangements. The problem gets to be when we read further in Huffman's affidavit, when he talks about that such an agreement may require facilities, and facilities aren't free. Someone's going to have to pay for them. And that's something that's going to have to be worked out by the parties. But here, the decision was made to avoid those costs, and it hasn't worked out fully. But the point is, what the commission is saying is that parties can work this out, and shippers in particular, as paragraph 17 of the rehearing order.
I had just a couple of questions in more detail on the similarly situated issue. How is this situation at this meter station different from the Liberty meter and the Kentucky meter? Why shouldn't we assume that where there's a common Texas Eastern pipeline, that some decision is being made to use pressure at different points and not where Range wants it?
They're completely different situations. The meter stations are with, I think, alternatively, a municipality and a local distribution company. Here you have a very different situation where you have an interconnect and you have this pressure dynamic between one interstate pipeline and another. And in this regard, the affidavit signs put on the record by Texas Eastern is good in that he addresses exhibits 10 and 11 that were provided by the complainants. And if you compare the two exhibits, he does this in paragraph 6 of his affidavit. This is a JA 828. And if you compare those exhibits, they line up, they link up, and you can tell that the volumes reduced to zero, where Columbia Gulf had through the confirmation process indicated that it couldn't accept the gas. That's the problem here. We have no indication in this record that a similar dynamic is happening at the meter station that is serving a municipality or a local distribution company.
On the force majeure issue, I had a hard time understanding why it would make a difference whether Range withheld payment or not, because I mean, if I haven't paid my credit card bill, I could still dispute a charge, or whether I have paid. I just didn't follow that logic.
Fair enough, Your Honor. I don't believe that's the central point that the commission was trying to make there. I think the central point was that the force majeure does not matter here. And I'd point, and because
It doesn't matter because there's no minimum pressure obligation in the first place.
that's true. And Texas Eastern never asserted that the force majeure is the cause of Columbia Gulf not confirming the scheduled nominations.
In 21.
And
They
I
say
would,
that's true for most, but not for these 10 days in 2021.
Because they said they gave credits, but the point is, are they required to give credits even for the 10-day safe harbor period? That's how I understood the claim.
but they didn't make that argument in their complaints. The commission, this is an important part of what the commission said at rehearing order paragraph 16, JA 974. Range never showed in its complaints and in the rehearing request that it would be entitled to additional credits. I think that's true. They don't flesh that out in the complaints. And so here again, and by not making the case as well in the rehearing request, there's a forfeiture argument under NGA section 19, 15 USC 717R, which requires that a party raise an issue with specificity. But they never spelled out this argument that the force majeure fundamentally was wrong and was invalid in some way. And in fact, if I can add one more thing, they actually say the opposite. Joint complaint, paragraph 86, JA 48, they say they reserve the rights to raise force majeure in the future.
Can I just, you may have addressed this, and I apologize if I missed it. So on the issue of whether there was a forfeiture of the part of the 6.2, section 6.2 argument with regard to the 750 pounds of pressure, are you saying that if they filed a new complaint explicitly raising that, that claim would not be barred by the commission's orders construing 6.2 or not? I guess I'm just trying to understand.
I think they could file a new petition, and they could explicitly, and as I alluded to, I don't think it would be that difficult to articulate this clearly. I don't know how the commission would resolve that.
Yeah, I guess maybe this is an unfair question. Do you read the commission's order as having resolved that claim implicitly?
I do want to, the commission, the claim was not made that Texas Eastern failed to operate the upstream compressor station at 750. Point number one. Point number two, the claim wasn't made that there's a causal link between such a theory and what their theory is that there's a pressure differential in the interconnection. I don't know if that's
I understand. I guess maybe the better way to answer the question is, do you read the commission's orders as saying that even if it were so pled, it wouldn't make any difference? They would still
the commission
prevail.
Sorry, the commission certainly said that they didn't make that connection, and that's specifically in footnote 39. I believe that's at JA 970. They explicitly said that Range didn't make the connection between the upstream compressor station and the interconnection.
Okay.
So there is no result of FERC's order that the Danville station has no obligation to operate at 750, which was one way I thought that the petitioners were reading it. There's no such impact of the FERC's order. It just didn't touch that issue.
Because it wasn't, it was
Danville
correct.
station.
I think that's correct, because it wasn't raised in this case.
Thank you.
Thank you, Your Honor.
Okay, and then we'll briefly hear from Mr. Etchemendy. I'm probably butchering that.
You actually weren't. You got it right on the first attempt. May it please the court, Matthew Etchemendy for intervener Texas Eastern. So there's a lot going on in this case. I'm happy to answer questions on anything. I did want to start on one point that hopefully I can clear up pretty quickly, simply, and that's this shipper issue in Northern Natural, because I do think that that's actually a really straightforward point to resolve. So Texas Eastern is unambiguously not the shipper here. The shipper is Range. And to Judge Wilkins' question about is there a definition of shipper in Columbia Gulf's tariff, the answer is yes. It's cited in our brief, page 31, note 8. It is also quoted in the joint complaint, JA 751. That's in a footnote to one of Texas Eastern's pleadings. But the tariff defines shipper as any person or entity requesting or receiving service under Columbia Gulf's rate schedules. So shipper is defined as a person buying service from Columbia Gulf, not an interconnecting pipeline. So there's no service contract here between Texas Eastern and Columbia Gulf. So there's really no real dispute that as a matter of definition under Columbia Gulf's tariff, and also just as a matter of ordinary industry usage, that Texas Eastern is not shipper here. So it's really not credible to argue that the provision applying duties to shippers under Columbia Gulf's tariff applies to Texas Eastern. I mean, that's just unambiguously not right. Now, there is still the question about what do we do with Northern Natural and the language in Northern Natural. So I would be happy to address that as well. So it is not true that the commission said that Northern Natural was a shipper on ANR. And it also didn't say that Northern Natural was bound by that language. What it said was that the analogous language in ANR's tariff applied, not that it imposed a duty on Northern Natural, just that it applied. And what did it mean by applied? Well, it resolved that there was no duty on ANR to adjust its pressures downward. The duty wasn't on it to ensure that the gas arrived at sufficient pressures. So that's what it meant by the tariff language applied, which is what it said. It didn't say impose an obligation on Northern Natural, didn't say Northern Natural is a shipper.
So it's sort of ANR as in contradistinction to Northern Natural and or its shipper and whoever determines the pressure of what's delivered to ANR. So it's not significant to the holding who's responsible for the obligations on the counterparty side of things. It's between the actual shipper and Northern Natural.
So the holding was that ANR did not have an obligation to adjust its pressures. That was just the holding. So it didn't say who, if anyone, had a legal duty otherwise.
What about the last sentence of paragraph 23, which reads, therefore, the responsibility to deliver gas at a pressure sufficient to allow the gas to enter ANR's system rests with Northern Natural. That's pretty clear. We don't have to interpret whether Northern Natural is a shipper or not. They don't use the term shipper. They just say straight up, the obligation rests with Northern.
So it doesn't say obligation, it says responsibility. And I think it's pretty clear in context that what it meant by that was that Northern Natural would bear the financial burden of making any necessary adjustments if it wanted to ensure that the deliveries occurred. And remember, Northern Natural.
I thought you were going to say that it's the physical responsibility and who ends up paying for it as a matter of contract upstream.
Physical responsibility. Well, I think what it was saying was that Northern Natural couldn't try to push an obligation onto ANR to make this change. What it was saying was, look, you're the complainant. If you want the pressures to be adjusted and for this pressure imbalance to be fixed, the responsibility is on you. And what it meant by that wasn't that there was some rule across the board on upstream pipelines that they have an enforceable legal duty to deliver at a certain pressure. It's analogous to saying that a buyer of goods without a warranty is responsible for repairs. It doesn't mean they're required to repair the goods they buy. It just means that they'd have to bear the cost if they did. And so I think that's pretty clear, and I think it's also just taking a step back here. It would be very strange if in this one passing sentence that comes at the end of an analysis of ANR's tariffs and contracts, if the commission had suddenly, without explanation, set some kind of default rule that altered contractual obligations on, essentially every pipeline in America.
I have a couple other questions about force majeure. If FERC had taken up the propriety of the force majeure declaration and held that it was invalid, would you owe Range reservation credits for the 10 days on which Texas Eastern reduced the deliveries at Adair due to the...
So Range still hasn't made a case on that or explained, what, if any, additional credits it thinks it would be entitled to. Now, what it does say is that it says it thinks that it may be entitled to more credits under this 10-day safe harbor provision. It says that on appeal. Did not say that on rehearing. It did not even hint at that on rehearing. In fact, this is nowhere in the record at all. That's why when they do on their reply brief eventually get around to quoting it, they have to use a web link rather than a citation to the record.
On things that weren't argued, though, did Texas Eastern argue that it didn't have any minimum pressure obligation at Adair in any event, so didn't need to declare force majeure as a result of the Pipeline Safety Administration's pressure restriction?
So let me clear up some things because the record's a little complicated on this, and hopefully I can provide some clarity. So Range and Columbia Gulf were afraid that Texas Eastern would try to evade responsibility, so to speak, in general for the pressure imbalance issues at Adair by relying somehow on force majeure or sort of blaming it on PHMSA orders. That didn't occur here, and that made a lot of the allegations and the complaints about force majeure and PHMSA sort of drop out of the case. What Texas Eastern, its argument for why it wasn't responsible for the gas that Columbia Gulf didn't accept was that it had no obligation in its tariff to deliver gas at a certain minimum pressure at the Adair interconnect. Now, there was a force majeure declaration that Texas Eastern made in late May 2021. That had nothing to do with the pressure imbalance issues at Columbia Gulf. It stemmed from a separate anomaly on one of the three lines, a corrosion stress cracking issue that led to a PHMSA order. So essentially what we're looking at here is at the same time that this curtailment was occurring in 2021 and where there were pressure imbalance issues at the Adair interconnect, there was a separate and unrelated force majeure declaration in effect stemming from this PHMSA order. As a result of that, there were some volumes that that Range nominated for delivery that Texas Eastern couldn't even schedule on the basis of force majeure. And for those, Range was given credits in accordance with Section 31.2 of the tariff.
But just want to make sure I understand. So in their complaint, they definitely do say that force majeure declaration was improper, and that if it's improper, it's on page 17 and 18 of Range's complaint. If it was improper, they should be entitled to 10 more days. And then paragraph 36 is, based on the foregoing, we respectfully request the commission determine Texas Eastern is responsible for providing reservation charge credits to Range for all volumes that Texas Eastern scheduled but failed to deliver. So how does that line up with what I'm saying?
So Range did not raise in its complaint an argument that the force majeure declaration was invalid. I'm sorry, if you could point me to the page again where you're seeing that.
It's JA 297 to 298. And I know it's difficult to do this on the fly, but it seems to me that's at least where this general topic is discussed.
Well, right. So what Range is saying there is that notwithstanding the fact that there was a force majeure declaration in effect there, Columbia Gulf, or rather Texas Eastern couldn't claim that, sort of wash its hands of giving any reservation charge credits. But what it doesn't ever say here is that Texas Eastern's declaration of a force majeure event was invalid or improper. And that was the issue that was raised for the first time on rehearing.
Thank you.
Just a couple factual questions. There's a meter at the Adair interconnect. Is it before the interconnect, after? Is it along the Texas Eastern pipeline or?
So the meter at the actual interconnect, or do you mean the meter stations?
No, I mean the meter at the interconnect. How do we know what the pressure is at the interconnect?
There is a meter at the interconnect, yes.
And that's in the interconnect or before or in Texas Eastern's?
So unfortunately, candidly, I don't know the
You don't
physical
know.
reality.
And so too with the Liberty and Kentucky Energy meters. What are they're measuring pressure in Texas Eastern's pipeline?
So they are measuring flows into these local distributions.
So it flows off,
Correct, off of Texas Eastern's pipeline.
so not the pressure in the pipeline.
So these, are you referring to the exhibits, the complaint exhibits talking about the meter readings?
The chart and yeah.
Yeah, so those are talking about flow numbers, gas
to
going
the
off.
distribution and the.
Correct.
And can you say which days between June 2021 and July 29, 2021 were affected by the force majeure?
Were affected by the force majeure, yes. So this is in the Donaldson affidavit at JA 708.
Right, it says a portion. I wonder.
A portion, yes, during the period from June 2nd through July 29. So that was the period where this separate force majeure declaration was in effect that led some nominations not to be scheduled. But to be clear, over the same period, there were also many nominations the range made that Texas Eastern did schedule. In other words, that it was ready and willing to deliver at the available line pressure.
I don't know which days were affected and which days were unaffected.
By the force majeure event?
Yeah.
Well, on many of these days, there would have been both. There would have been both nominations that were scheduled by Texas Eastern, but not delivered solely because Columbia Gulf didn't accept receipt because of the pressure imbalance. And there would also have been some nominations that were not scheduled due to force majeure.
So during the period between July 30th and August 3rd, when Columbia Gulf elected to receive 203,542 decatherms, but the Adair meter was reading only 131 decatherms flowing. Why is there a difference there? Is that attributable to the force majeure?
That would, I think, principally be due to that would have been due to the pressure imbalance in Columbia Gulf's refusal to take receipts.
Well, they're saying they elected to receive 203 decatherms and the meter's only reading lower than that. So I'm trying to figure out if they think they're ready to receive more.
I apologize. Is there did you know which page that was, or I could look it up, but I'm not recalling that allegation.
I just wrote notes. I think it's from Donaldson. Sorry, we'll skip it. It's been a long day. Are there questions from my colleagues?
I actually do have one last question, just on this reservation charge issue. I understood you to say Range never made a claim that they would be entitled to more reservation credits if the force majeure declaration was wrong, was invalid. And the last thing that's tripping me up is paragraph 16 of the rehearing order, which says Range has not shown it would be entitled to additional credits for this category of reductions, even if the force majeure declaration had been improper. seems to be assuming they're arguing the force majeure declaration is improper and saying, even if they're right, they're not entitled to more, to which I understood Range's answer to be, we'd be entitled to 10 more days.
Right. So just to respond to that
Yeah,
quickly.
please.
So in the complaints, as we've said, Range never did argue that the force majeure declaration was invalid. In fact, it explicitly disclaimed that, as the commission noted. That being said, as you note, that wasn't really the commission's holding when it rejected this argument. As it said, I do think it provides valid or useful context. But what the commission's holding was that Range had not asserted or showed that it would be entitled to more credits if the force majeure clause were invalid. And that's in the rehearing request. It never did that in the rehearing request. So that was FERC's holding, that Range is making this argument on rehearing, and it has not asserted or shown that it would be entitled to more credits even if the force majeure clause were invalid. Therefore, we don't need to hold a hearing on it. And that was absolutely a correct holding. If you look through the rehearing request through those pages, you will see absolutely nothing about this 10-day provision. And their effort to raise this for the first time on appeal is jurisdictionally forfeited, and it's very clear under this court's cases that arguments must be raised with specificity on rehearing.
Thank you.
What is the value to Range of a firm contract as you and FERC read the documents here?
So the value to Range of a firm contract is that it has service on Texas Eastern, and that service, as opposed to interruptible service, is not subject to a prior claim by another shipper. So we can't not serve them because we're too busy serving someone else. That being said, I take your question to be, well, what is the value of this agreement to Range if this pressure imbalance can come up? And Range is sort of tough. I mean, I will point out a couple of things on this. First of all, Range is getting value from this contract. I mean, we're talking about, just for context here, we're talking about a period of about a week in 2019 and then a certain period in 2021. So we're just talking about those periods. And even during those periods, Range was still having gas delivered. Now, there were a few days where it was zero, but overall Range was still getting gas delivered. So, Range is getting value out of this contract. Essentially, what Range is looking for here in trying to impose a mandate on Texas Eastern or on all upstream pipelines or delivering pipelines to always deliver at minimum pressure across an interconnect, it's basically a form of forced insurance, so to speak, or forcing Texas Eastern to bear the costs that would necessarily occur, such as building additional compression facilities, to ensure that pressure imbalances like this never arise. And the approach that the commission, has landed on, and this is not a new thing, is that it's a contract-based approach, and rational market actors can decide whether or not it's worthwhile to them to pay the extra costs that would be involved in having this kind of, avoiding in advance these types of issues that may or may not crop up in the future. And there are lots of reasons why they might not want to take on those additional costs of installing, for example, additional compressor facilities.
Right. That's helpful. Thank you.
Thank you, Doreen.
And we have some rebuttals. Mr.
Yes, Your Honor, I recognizing that we've all been here a long time today, I will be very brief in my response and rebuttal and hopefully save some of this time from my colleague as well. Just really briefly on your last point, Your Honor, about what is the value to Range in this contract if there's no guarantee of service. Firm service is supposed to mean firm. There was some discussion with Mr. Eidiger about why can't you just renegotiate the contract? We have a Mobile Sierra issue there, Your Honors. If we cannot get FERC to undo the contract unless there's a public interest problem. We've already seen what FERC thinks about the contract, so we have that problem there. I would note also the standard industry practice for interconnection agreements or for agreements where delivery pressures are applicable is where the counterparty to the contract has some knowledge about what the delivery pressures are. That would be something like a power generation facility that has turbines that need to have gas coming in at a certain pressure. That would be a local distribution company that has some knowledge about the pressure that it needs for its system. A shipper has no way of knowing other than examining the publicly available MAOP information for the upstream and downstream pipelines to figure out what the pressure could be. But the point I'm trying to make is even if we could renegotiate the agreement with Texas Eastern, what would we put in that agreement? So thank you very much, Your Honors.
We'll also hear briefly from Mr. Higgins for Columbia Gulf.
Thank you, Your Honor. Just very quickly, just wanted to make 3 very brief points in response to what I heard this morning. One is with respect to Columbia Gulf's tariff and how it defines shipper. I'd note that ANR's tariff at section 5.1.1 defines shipper in the same exact way with reference to rate schedules. Who takes advantage of rate schedules is a shipper. Under ANR's tariff, it's the same definition under Columbia Gulf's tariff. There's no way, at least I haven't heard any way from FERC during all these proceedings, to distinguish Columbia Gulf's tariff in this case and ANR's tariff in Northern Natural. Second thing I heard was a statement that in Northern Natural, the delivering pipeline was not bound by the receiving pipeline's tariff. But again, paragraphs 14 and 23, read in conjunction, simply do not permit that interpretation. Again, paragraph 14, tariff provision requires Northern Natural, the shipper, to deliver gas to ANR at pressure sufficient to enter into the pipeline. That was ANR's argument. And then paragraph 23, we also concur with ANR's interpretation of its tariff requirements. Very plain. And the very last point I wanted to make was just a response to one of Judge Wilkins' questions, that FERC never acknowledges that it made this statement, and it would be very easy for FERC on remand to simply say, yes, we did make that statement. Here's what we meant by it. Here's why it was wrong. Here's why it applies. Here's why it doesn't apply. FERC, throughout these proceedings, has never acknowledged that in Northern Natural, it applied substantially identical language to the delivering pipeline. We have narrow relief for FERC to have to do that on remand. If there are no further questions, we ask that you grant the petition. Thank you.
Thank you.
Court now stands adjourned until 2 p.m. Friday, September 29th.